Hmm. Yes, call. Yes. We'll see. Let it come. Let's next week. Next week. What is the urgency? What is the matter? Contempt. We'll see next week. Hmm. Hmm. Friday. Friday. Huh? Day after tomorrow. Friday. Why? 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 What lasted? Huh? What is the guarantee that you will be allowed to participate once you have blacklisted? We'll see then tomorrow. Next week. Next week. 32. Withdraw. Ah. Which for the petitioner? Mr. No objection. H for learned counsel for the petition. LL counsel for H for learned counsel appearing on behalf of Mr. P. Gogoi, learned standing counsel PWD. Further, 3 weeks' time is granted to file affidavit. List of Mr. Ersing, learned counsel for the petitioner, is present without by giving consent. Huh? By not giving consent, by not raising objection. Yes. Why? Huh? When it was to be listed again? Second of September. Monday. Why? What is the system here? It was supposed to be listed when again? What is the system? Hmm? After a week. Hmm. But it's supposed to be listed. Then it is time barred. If it is time barred, you are not entitled. We cannot consider. Hmm? Okay, next week we'll see. Yes. Item number 46. IA. What is the matter? Tender matter. Call it. Implement. Call. Complied. Who is appearing in the Alice Contempt? Who is for the who has appeared? Huh? Additional AG, B. Gogoi. Who? At least he could have. Can he not speak? Huh? Yes. Yes, we'll close that in that case. There's no contempt once it is paid. We'll record his submission. Heard Mr. P. Sharma, learned counsel for the petitioner. Come on. It is stated, it is submitted by Mr. B. Gogoi, learned additional AG, Assam, for Alice contempt number 1 and 2, that the amount as per the undertaking by the Alice contempt number 1 and 2, an amount of rupees 22 lakhs 50,799 has already been paid, paid to the petitioner. Please stop. There's no other issue. 2 lakhs has already been paid. No, bro. Attention, which was illegal director to had already been paid. Please stop. In view of the above, there's nothing remains in this contempt petition. Please stop. Accordingly, contempt petition stands closed as being duly complied with. Yes. Have you filed the additional affidavit? What is the additional affidavit? No, why this additional effort is all about? It's okay. I know, Tamsir Ali. You tell us why this additional affidavit. Who is below you, below serial number, below you? It's not been paid in serial term. Okay, we'll issue notice. That's all. It's okay. It's okay. Heard Mr. So-and-so, learned counsel for the petitioner. Decision application under section so-and-so, so-and-so. Read of section 12 of Contempt of Courts Act 19, read with Article 215 of the so-and-so, and Guwahati High Court so-and-so, alleging willful and deliberate disobedience of the order dated 29/04/2024, passed in WPC 2152 of 2021. Issue notice returnable by 4 weeks. Petitioners to take steps for services of notice upon respondents. How many respondents? 1 and 2. Where is that post so and so? Within 2 days. Item 2. Saying that there is no record available. Huh? Where it is? Where is additional affidavit? Additional affidavit not yet received. Huh? This is office note, 1908. It is submitted by Mr. Njego, learned counsel for the petition, that an additional affidavit has been filed. Mr. However, it is seen that the same is not tagged with the petition. Registered to verify and take the additional affidavit with the contempt petition. List after a week. Yes. Additional affidavit. What? So unless we know that it is confirmed that they have received. Understand, but how do you issue notice? Okay. So in that case, we'll say you withdraw. Then will you withdraw? Close on what basis? Okay. It is Mr. So-and-so, then counsel for the petitioner fairly submits that the petitioner could not place on record the proof of submission of the certified copy of the order of this court dated with the order 26/3/2025, passed in WPC 7026 of 2024. Therefore, the contempt petition may be closed. Yes. Next paragraph. In view of the submissions and considering that until the time the petitioner could show that the order of this court has been submitted before the authorities come up. It will be difficult to issue even a notice to the respondents in view of as submitted the contemporary restraints clause.
With liberty, my lord, that will be helpful.
Needless to observe that the petitioner may take appropriate steps for submissions of or separate copy of this order that is so and so before the appropriate authority, concerned authority.
Yes, sir. Item 4. This is a contempt petition, my lord, for violation of your lordship's order dated 13/5/25, my lord.
Yes.
It starts at page 14, my lord.
14.
14, my lord. And
Yes.
the operative portion, my lord, is at page 16. Okay, kindly come to paragraph number 6. The affidavit of the respondent number 3 also shows that there is an admission that the petitioner is entitled to rupees 15,84,326. In view of the admitted fact that the petitioner is owed rupees 15,84,326, and as necessary approval has been given, the finance department.
So when did you submit your application, the copy?
My lord, annexure to page 18.
So where is the acknowledgement?
My lord, that we have sent it by registered post, my lord. That is at page 20, my lord.
Same thing.
My lord.
How do we know whether they have received or not?
Taking concernment shows, my lord, it has been received by the office, my lord.
Where it is?
But those who have annexed at page number 20, my lord.
How do we know from here whether it is the acknowledgement or not? Same thing, earlier matter. That's why your colleague has fairly submitted, they could not place the proof of submission. Unless you show that this has been submitted and it has been, same has been acknowledged. It's difficult.
Can you take it up next week? We'll file an additional affidavit.
Okay. On the prayer of so-and-so learned concept of the petitioner, miss this matter after a week, so as to enable him to file additional affidavit to bring on record the proof of submission of certified copy of the order before the appropriate authority. Before the concerned authority.
Item 5. This is in respect of a contract for drilling rigs, my lord. There was some delay, my lord, and the extension was granted up to 20th of June, my lord. Then, my lord, 13th of June, we said that it is ready for starting, but they inspected on 16th and they made some observations. We are completing those observations, my lord, up to 4th. But on 5th, my lord, with retrospective effect, it was terminated. But by 15/7, my lord, we are ready. We are totally starting, my lord, ready for starting. So there is no difficulty at all, my lord. On 15/7, my lord, we are ready for starting. So I think, my lord, they can slide it, my lord, because we have filed a defense also. In this aspect, it is very much required also for national interest. So on 15/7, my lord, fully is ready, my lord. Some, my lord, delay is there, my lord. On 20th, my lord, they have given the extension, 20th June. We can give a list of short list of dates also, my lord.
No, the contract has been terminated.
Terminated retrospectively, my lord, on 5th of July, with effect from 21st. But on 23rd, they made some observations, my lord.
Saying what?
That these are to be clear.
So you have clarified that.
And we are clearing, my lord, and we completed on by 15/7.
Where it is?
Well, yes, I am coming, my lord. Your lordships may just take the list of dates, my lord. First, my lord, third page, my lord, your lordships will take, my lord. Third page, last, my lord, per 16, item 16. Petitioner by this email letter so intimated respondent authority that the rig package is completed for spudding and accordingly requested them to inspect the site and assess the rig readiness. Then 16/6 RI visited and inspected the site. On 18/6, my lord, the respondent authority furnished as many as 190 observations with the petitioner company requesting them to necessary corrective action. 19.6 petitioner intimating the hindrances to ensure this is not necessary. Then 23rd one, last one, 21. Respondent authority furnished observation made by the instrumental section during inspection on so and so. So on 23rd also, my lord, they made some observations.
After the termination,
After that,
on your representation.
termination is on 5th, my lord. 5th of July, but we have to stay at that. So we have now, my lord, made fully complete, my lord, 15.7. I think, my lord, they can take it, my lord, my lord.
If that is
They have had a additional.
Affidavit, my lord.
172. Just wait, sir. 170,
170.
there's no additional affidavit. The writ petition is, last page is 171.
They have filed a.
There's no evidence. But then, sir, what remains? If you have reconsidered and they have also, I mean,
What they have stated.
yes,
The petitioner submitted upon instruction of the respondent, they are ready to start operation 4.
yeah,
That means it is ready.
yes,
Have made an inspection after getting this. And our team has also said that it is ready. In 48 hours or in 1 week they can start.
yeah.
If that is the position, then we have no objection, because otherwise we have to again go for a paid tender process and
Yes.
delay it another 1 year to maybe 2 years. So if they are given commitment before this honorable court that they are honored, they will honor this paragraph 2 statement.
Ah,
If they can immediately say, and another point also, there is a clause of penalty, if there is a default in the part of their mobilization. If that is there, and if they are ready to pay the compensation to all, we are ready to allow them to.
My lord,
Upon instructions and some.
yes.
my lord, we are ready, my lord, because as per the clause, my lord, liquidated damage is there. And we are ready to pay.
Have you mentioned in your additional affidavit?
Actual affidavit, we have, no, we have mentioned, my lord, that
No, whatever the
yes, ready, my lord, ready from 15.7.
ready is one thing, 2, 3 condition
Additional affidavit, my lord, that I am,
penalty.
I with all my instruction, my lord.
Have you mentioned it?
No, this, well, the thing has not been mentioned, but it is as per clause 40, my lord, liquidated damage is there.
You beg that this thing, mention it, we'll take it up on Friday, we'll dispose of the matter, and short order will pass.
Yes.
Because tomorrow it should not be complicated. Because if you are agreeable to,
No, agreeable, my lord, your lordship may make my submission, my lord, as in here. Because that may be recorded, my lord.
okay.
Undertaking, my verbal undertaking may be recorded.
So the termination is no issue is no longer there.
Allow them, we'll recall the termination.
Okay. So do we need the court's order in that matter?
Well, that is the-
Once you close it, so that as, why we are not objecting, because they have completed the work.
Okay,
It's ready for functioning.
okay.
On top of that, if they are agreeing to pay the penalty part, we have no objection for any reconsideration.
Okay. Okay. Had Mr. G. N. Sahiwal learn counsel for the petitioner, and also had Mr. D. Saike learn senior counsel,
Senior, that will
not as a learned as a
not.
senior counsel, assisted by Mr. P. Nayak, learn counsel for the respondents, all the respondents.
Yes, 2 respondents, my lord.
By filing this writ petition, petitioners essentially has put to challenge the
Order dated 5/7,
order dated 05/07/2025
page 164.
and letter dated 007/2025. Where it is page
Page 164, my lord, first one termination. 164.
164,
Yes.
issued by the respondents whereby the contract, page 164, big number 61200 so and so, page 164, charter fire of 01, number of 2000 HP within bracket minimum drilling rig package has been terminated
With effect from 21,
with effect from 21
6, 21, 6, 25.
with effect from 21/06/2025. And other letter is what?
Well, another letter is, my lord, to remove it.
And the consequential letter to vacate the allocated present drilling location.
Yes.
That's BJA, page 166. List of this process of revisiting
Yes.
or the kind of settlement is during the pendency of disputed person. Okay.
My lord, your lordship, find that last page, my lord. There.
Last page of what?
My lord, this list of debts.
Yes. So during the pendency only. Okay. Okay. Considering that the parties have
The deed is, my lord, complete that for starting. I'll get maybe.
no, it's okay. Considering that the parties have entered into a kind of settlement on revisiting the dispute on the basis of the representation dated 06/08/2025, as this and as agreed to by learned counsel for the part, learned senior counsel for the parties, this writ petition is disposed of at the motion stage with the following observations. We'll say observation. Next paragraph. Observation. Since number one, since the petitioner has intimated by its email dated 13/06/2025 to the respondent authorities that the rig package is completed for spotting and accordingly requested them to inspect the site and assess the rig readiness, to which the respondent authority inspected accordingly and furnished a certain observation to the petitioner requesting for necessary correction actions, and the petitioner is ready to what do you call?
Ready to,
Ready to
complete study.
ready to complete the spotting.
Yes.
Okay. Okay. Same shall be allowed to be completed. Same shall be allowed to be completed. Okay. We'll have to I said should be allowed to complete the spotting. Completed.
That's the document is for the
This spot has to be mentioned.
opinion is that it is ready for operation. That is number one.
Yes.
You documentary papers they have to complete that formally.
Okay.
That is number two.
Okay.
That also complete. Additionally, I am saying Lord that they are ready to pay the penalty as per the contract agreement.
Okay. That's
Or default in the not completing the mobilization within the time.
okay. Next para, number 2. As the rig is ready to start the operation, the equipments, the few equipments which are not as per the TNC, terms and condition of the agreement,
Yes.
shall be made available.
Within a week.
Made available within a week. Discrepancies as observed on the documentation part are to be rectified before prior to the start of the operation.
They are ready to give
For
delaying mobilization.
the petitioner is ready to
Pay the liquidated.
pay the liquidated damage
As per contractual term.
as per the contract agreement. Contract agreement.
For delaying mobilization.
As enshrined in clause 13.
0.4.
13.4. 13.
0.0.
30.4.
No, zero.
Oh.
30.0.
Okay. 0.0. Okay. That's all.
Huh?
With the observation. The repetition streams closed. Disposed of. That's all. But according to this court, if that has been entered into, I feel court's order is not required. Could have withdrawn the writ petition.
That will be binding on.
Okay.
So they are basically giving concession.
Yes. Okay.
That's right. Could have fought the case. It was in our favor.
Okay.
But that will delay for 2 years.
Yes. Yes. Okay.
We have taken, a very pragmatic step.
Okay. Okay.
I know.
You want it back? Want to take it back?
Yes. And this will be. I have the records to give concession. That's right.
Okay. Okay. This is.
I know.
Yes, sir.
May it please your lordship. This matter, your lordship, the petitioner was allotted a contract of your lordship laying optical fiber cable in Excise form of a distance of about 23 kilometers. Your lordship. He constructed about 11.613 kilometers, which was under the PWP. Thereafter, the subsequent part, your lordship, just making a brief submission of that. Subsequently, he came upon.
You could not complete the entire
No,
stretch.
we could not complete because
So
of.
you want only the amount which for
that
which you have
basically,
constructed.
we have.
But what is the amount, total actual
total
amount?
Amount was on the last occasion, your lordship,
Yes.
that my, your lordship has asked the amount that we have taken instruction. It is about 22 lakhs. Your lordship. But that I have to bring on
bring
record.
on record.
Yes, I have to bring on record.
After a week. All right.
We are disputing. We are saying.
You dispute, let them.
Yeah, let us put it
Let
on
him
record.
let him put on. First him have the affidavit.
I'll put it. I've got the instructions, I'll put it on.
Okay. Mr. Manan, learned counsel for the petitioner submits that he may be granted a week's time to file appropriate application and additional affidavit to bring on record the actual amount which the petitioner is entitled to. Mr. Prayers allowed. This the matter after a week, so as to enable the petitioners to bring on record the actual amount, the actual amount which he is claiming. Record your name. Should I record? We are not issuing any notice. at this stage. Is it required? If it is required, we'll say, Mr. B. Pathak, learned counsel for BSNL, respondent 2 and 3, and
2, 3, and 4.
2, 3, and 4. Respondent number 6. Are ready to appear. Are present, just say, are present.
Obliged.
Yes, sir.
May I please, Your Lordship?
Huh.
Lordship, in this matter, the petitioner was a porter in Guwahati railway station. And due to an incident on the 1st of April 2018, the GRP wrote a report against him, which resulted to his revocation of license as a porter and his ability to work in that station. And all this was a result out of an order from
Well,
the
issue notice at best. Heard Mr. So-and-so learned counsel for the petitioner. Where is this cancellation?
page 9,
Uh,
28, Annex 7,
28, 20.
28.
Challenge made in this writ petition is to the communication, huh?
Yes,
Communication, page 28, huh? Number so-and-so, so-and-so, dated 19/11/2019, 2019.
representations were filed.
Issued by the assistant, what is it? Commercial manager,
Yes,
Guwahati, NF Railway. NF Railway, whereby the badges of the whereby the porter badges, what do you call it?
Porter,
Huh?
porter,
It's a porter badges,
badge, porter,
license, huh?
license.
License badge of 3 persons, including 3 of them.
One, we are represented by one. The
No,
order-
anyway, by this letter 3,
Yes, yes.
3 of 3 persons, including the petitioner, have been cancelled with immediate effect. Petitioner, next para, claims to be a porter, what is called? Who you are?
Sikandar Chauhan.
Is a licensed porter bearing number 87 of Guwahati railway station. Christoph, according to the petitioner, the cancellation, the authorities have illegally and arbitrarily cancelled the porter badge, a license badge of the petitioner. Christoph, issue notice returnable by 4 weeks. You are appearing for all the respondents. Mr. Learned Counsel, since Mr. S. Bortakar, Learned Counsel enters appearance on behalf of all the respondents, no formal notices, however, extra copies be furnished to the Learned Counsel for issuance.
Obliged.
May I please, Your Lordship?
Yes.
Lord, in this petition, we have Citizenship, my Lord, decided that 8/7/2025 at page 57, my Lord.
57.
Yes, my Lord. And next slide 12, my Lord. The allegation against me that, my Lord, I have failed to deposit the quarterly installment for my mining contract, my Lord. And my Lord, regarding the payment issue, my Lord, we have already informed the concerned authority, my Lord, regarding my Lord,
3/5/2025 on my lord page 52. Yes, sir.
Yes, you have been given chance to explain. You have been asked to explain
Yes, ma'am. We have already filed a reply, my lord.
why the mining contract area should not be cancelled. So take instruction. You consider it unnecessary.
My lord, another.
If once decided again, he will have to come back, and obviously you will cancel. It's not it. It is obvious. It's all right, but obviously you will cancel it. Why harassing him? Let it go. Let him approach this court once, not twice.
My lord, I have one submission, my lord, from my lord 29 March.
See, unless they
2025.
decide, you have submitted the the reply. Anyway, we'll just ask for instructions. Heard Mr. So-and-so, learned counsel for the petitioner. Challenge made in this writ petition is to the communication dated 08/07/2025. In fact, it's too early. Issued by the Divisional Forest Officer, North Kamrup Division, Rangia, whereby the petitioner is directed to explain why the mining contract area should not be cancelled in view of the fact that the petitioner has failed to deposit the quarterly installment money of fifth year first quarter along with interest after lapse of 60 days from 01/05/2025 to 30/06/2025 without any information. List of the petitioner submits that he or she has filed his reply to the Divisional Forest Officer, North Kamrup Division, Rangia, on 25/07/2025. However, and claims that the respondent authority has failed to consider the same. List of considering above, let this matter be listed after a week. Mr. R.R. Gogoi, Land Standing Counsel, Forest Department, to obtain instruction.
Public.
Anjali Das. Yes,
May be allowed to withdraw your motion.
withdraw.
Yes, sir.
It's better. Mr. So-and-so, learned counsel for the petitioner submits that he may be allowed to, he has an instruction to withdraw this writ petition.
Lordship, with liberty to file a fresh on.
What liberty? What liberty? Then we will not allow. With a liberty to file afresh. Mr. Gogoi, K. Gogoi, learned standing counsel. Additional senior government member for all the response is present. Considering no, the prayer for withdrawal is accepted. Please stop according the reference stands closed on withdrawal with the liberty as prayed for.
Obligers.
Make little question.
Yes.
Outstanding contract bill, my lord, not been paid to the petitioner. Petitioner has completed work, my lord, for construction of road for the visit of honorable governor,
So at best we'll issue notice.
my lord.
Yes, Gogoi. Who has to pay?
The BCC was. I will have the instruction.
Okay. Instruction or issue notice?
No.
Notice, sir. Heard Mr. So-and-so, learned counsel for the petitioner. The by filing this writ petition, petitioner has prayed for a direction to direction to pay the outstanding contract amount of rupees 35,69,000 with 12% interest for the work of what?
Yes, my lord, I have mentioned.
What is the name of the work?
Yes, I have mentioned.
Work
paragraph-
for the contract work
Paragraph 2, my lord.
of repairing of road from NH 31 within bracket Bagribari within bracket close to Mahamaya Mandir in connection with the visit of Honorable Governor of Assam at Mahamaya Mandir on 22/08/2023 for the year 2023-24. Issue notice returnable by 4 weeks as Mr. B. Gogoi, learned additional advocate general or what? Additional advocate general for Eastern and Mr. R.K. Musari, standing counsel for BTC. Answer assurance and accept notice on behalf of all the respondents. No formal notice need be served. So I would actually copy be furnished.
Published.
Item 11.
Yes, sir.
May it please your lordship. Would my lord be pleased to turn to page 10
Ha.
with a very narrow campus, my lord?
Ha.
Page 10. All we are saying is that under the excise rules, when objections are raised, there is a requirement under the law to meet the objections. Now they are proceeding to go ahead with the settlement without meeting the objections. They can do it in a very short time, my lord. My friend on the other side would not object, I think. That's precisely section 89.
Page
Page 10.
10.
Page 10. This is the problem. And all the annexures would lead to the objections.
Who are you?
Well, I am a person of the locality who had raised a complaint, as also like others who had also
Then
raised.
why don't you file an PL?
Well, section 29
Yes.
of the Act, as also rules 289(1) and 295 of the rules, excise rules, my lord, they lay down the procedure when public would raise some objections, they have to give a hearing to that. That's all. They're near a school, they're near the license is granted near a school within the radius permissible.
You are the residents of that area.
We are. So what I'm praying, my lord, if they fix a short date within which they can dispose of all these complaints as to their very short date.
Which rule?
My lord, Assam Excise Act, my lord,
Yes. Manual.
29.
Page.
If we're having the same book, page 15 it would be,
Assam Excise Act 2000.
my lord,
Yes.
29.
This is the book.
My lord, this is the book you carry. Section 29.
Section 29.
29.
Asserted in local public opinion, right?
Before the licenses are granted in any year of the retail sale of any intoxicant, the collector shall take measures in accordance with the rules to be made by the state government in his behalf, as may best enable him to ascertain local public opinion in regard to the licensing and location of shops. This is one. And the others are Rule 289(1).
Liquor shops of any district shall not be located sites to which the neighbors object on the ground which upon inquiry appear to be reasonable and free from malice or alternate. So,
And 295(3). 295(3), my lord.
for the
In
purpose
substance-
of Rule 289, 299, 299, objection from the owners or occupiers and residents of the Yes,
In
on the
substance-
basis of this, you can move the PL jurisdiction
But so far as
for
It-
invocation of PL jurisdiction.
Well, so far as this petition is concerned, since they're proceeding with the giving of the award, my lord, which my lord finds at page 14, 14,
Hmm.
14, but it's pretty back, but they have not yet finalized till date.
Hmm.
So possibly they would come up with a solution. Page 14, my lord.
Hmm.
It has been given to the first one, Sri Ankit Sharma, who's a private respondent hearing.
Hmm.
They may take their time, but it can be done in 7 days' time also. But only a hearing is required. Whoever is required would come to public notice and a hearing would be there. Once and for all, they can take a call. That much, my lord, nothing more. Because they have not finalized the date. And this is minutes of 2024, 27 to 24.
Hmm.
I mean, 27/9/24, my lord, which was of the minutes of 2002, February 24. So it's more than a year. They have not finalized. So they can finalize, certainly they can finalize, but let them have a hearing on that and go ahead with the matter. That much. We do not object to them, the gentleman being awarded with some license. Only thing is that objections be taken into consideration and they may pass an order. I leave it to your lordship.
A bit reluctant.
I understand, brother. But
This,
I understand.
see, if they are not following the due procedure or the act and rules,
My lord.
it could be a basis for public interest jurisdiction to be invoked.
True. But since these are statutory remedies, the statute says follow in a particular way, we raised an objection following the statute, so it would be their bound in duty to
No,
respond to
basically this is for the violation amounts to, I mean, affecting the public interest at
that.
large,
Public interest,
not your personal interest.
not the personal interest though, but since it comes down not to a public at large, but to the neighborhood concepts
The
in and around the
common
neighborhood.
yes.
And it is them who's going to, because objections are there on record, only to take a call and pass an order, my lord. That much they may have.
So the reason being it will affect the school children and all the
They may take a
people
call.
around.
They may take a call in 7 days' time, my lord. I'm not praying for a stay also.
Yes.
7 days' time, Lordship will dispose of the petition. 7 days they may take a call.
No, they file a complaint if you say that they need not be required to be heard and all because they are not entitled to file this objection. They are not affected. You decide whatever is there.
Lordship.
After 10 days, we'll fix it after 10 days. But this code is regarding maintainability. I mean, bit,
Well, so far as a person.
we'll see on next day. You take you obtain instruction after 10 days. Yes, can you obtain instruction? Heard Mr. S. Banik, learned counsel for the petitioner. The simple case of the petitioner is that the authorities are in the process of issuing a letter of acceptance in favor of one
Respondent number 7, Ankit Sharma.
Sri Ankit Sharma, respondent number 7, hearing, for grant of IMFL, Indian Made Foreign Liquor, OFF, of soft for THK 14 at Kachuajan, Tinsukia, pursuant to the NIT. What NIT or what?
Page 14, my lord.
Pursuant to the NIT dated?
No, we have the minutes of the financial bid evaluation. They call for that. We do not have. Page 14 we have.
Pursuant to the tender, huh?
Tender.
We'll see. On the ground that the authorities have failed to comply with the provisions of Assam Excise Act 2000 and the rules made thereunder, huh? List of, it is next pair, huh? Contended by the land council for the petitioner that the petitioner contended that the petitioner and other persons who are the residents of the locality where the IMF offshop is sought to be granted, have filed the complaints in terms of the Act and rules, above Act and rules, however, same is yet to be considered by the respondent authorities. Next paragraph. Considering the limited prayer for passing of speaking order, for a direction to pass speaking order in terms of the Act and rules, above Act and rules, comma. Mr. Sir R.R. Gogoi, Landed Standing Council, Excise Department, is directed to obtain instruction. List the matter after 10 days. Please.
My lord.
Yes.
Commissioner vehicle was taken high by the district administration, West Karbi Anglong, on
Hmm.
different dates, from 1/2/2023 to 36/2024.
Well, issue notice. Heard Mr. So-and-so learned counsel for the petitioner. By filing this writ petition, the petitioner has prayed for a direction to release the payment of an amount of rupees 638,148, 6,38,148 on account of the hire of the petitioner vehicle by the respondent authorities for the year,
That is from 1/2/23
for the period 1/2/2023
to 36/2024.
to 30/06/2024. That's all.
Yeah.
Issue notice returnable by 4 weeks. As Mr. B. Gogoi, learned additional advocate, then enters appearance, except notice on behalf of all the respondents. 1, 2, 3, 4, and 5. Others? Who is the standing counsel? For the respondent, all the respondents. No formal notice need be mentioned. Extra copies. Extra copies. Yes, sir.
You know, it's a tender was issued by the respondent number 3, you know.
2017, sir.
My lord. Well, they, what happened, my lord, procedure is, deputy being a tendering authority, he forwarded the entire tender record to the government, my lord. Government, instead of completing the process, sitting over the matter. In fact, in 2024, I filed an application and deputy commissioner on my basis wrote a letter. The object of the fishery rule is to promote economic condition of the scheduled caste.
Almost 8 years. 8 years.
My lord, I understand.
Yes, madam.
They are sitting over the matter. What to do?
Page? Yes. Madam, can you use the mic?
My lord.
Yes.
From my lord 6 line, therefore, my lord, the tenderers are invited from interested tenderers for settlement of the aforesaid fishery for a period of 7 years, my lord. So my lord, period has already been,
But what had happened?
But then,
my lord, I have to take instruction from the department, my lord.
where is the object, my lord? Object frustrated, my lord, here.
Well, ask for what had happened. Let us understand. Let us know.
Yes, yes, my lord. But
Only-
in fact, in 24, my lord, Annexure 3, Deputy
It is only for 7 years.
the-
No,
yeah,
it's now where it's more than
under
8
the-
years.
Under the fishery rule, 7 years start from the date of handing over of position.
Ah.
Yet, handing over of position has not taken place. Even the settlement order was not issued. They're sitting on the middle.
There's no operation now. Nobody is operating.
No, my lord.
I have to take instruction, my lord.
Take instruction next week. Ah. Let us find out
My lord, my lord.
what had happened. Okay.
Very-
So today we'll not issue notice. We'll not issue notice today.
Look, it can be.
Heard Mr. S. Kotoki, learned counsel for the petitioner. List of the petitioner claims to be the highest bidder in the NIT dated 04/03/2017 for settlement of what?
Number 25, Kataktoli, River.
Number 25, Kataktali River Fishery under Borpeta district in the state of Assam has prayed for a direction to settle the matter in their favor, in favor of the petitioner. Please stop. Considering that the tender appears to have been issued in the year 2017 for a period of 7 years, and by now already 7 years have elapsed, MS so-and-so,
Sutia, my lord.
SUT Learned Council, Standing Council,
For respondent 1 and 2.
for which Standing Council for
Fishery department.
Fishery Department for Respondent 1 and 2 is directed to obtain instruction. List the matter after a week.
My lord.
Extra
Yes.
copy we furnish him.
Can we ask?
My lord.
Please, your worship.
Yes.
My lord, some contract works were completed 3 years back. So the joint verification report and work completion report, everything is given yet, my lord,
What contractual work?
it's like, my lord.
How much amount you are claiming?
11 lakhs, my lord.
And Mr. So-and-so learned counsel for the petitioner. By filing this writ petition, petitioner has claimed for payment of an amount of rupees
11 lakhs.
11 lakhs on account of the execution of work of restoration of flood damaged road from Sarai Hagi to Dakin Sanka Chaki under Batadraba, Ding and Raha Territorial Road Division, Nagaon. Police, you take this from page 20, 12 and 13, huh? Prayer process. Issue notice returned by 4 weeks as since Mr. B. Gogoi, learned additional advocate general for all.
My lord, 2 and 3, they are standing counsel in the revenue department.
For
Jay Hendik name is
Respond-
reported now.
huh?
Jay Hendik. For
Jay
2 and 3.
Additional
Yes,
advocate
I'm-
general and Mr. J. Hendik, huh? Learned standing counsel for revenue department.
For 2 and
Enters
3.
appearance and accept notice on behalf of all respond no form in assurance. Huh? Extra copies
Jay Hendik will appear for respondent 2 only.
will say. So
3 I'm appearing.
Hmm.
3 to 6.
it's okay.
Only 2.
I said all the respondents
Not
by recording both of your name.
15.
Lordship,
Yes, sir.
non-payment of contractual bill, Lordship.
Hmm.
Bill is Lordship in page numbers 22 and page number.
How many? How much? Sorry.
Lordship, 63 lakhs, 12,355 lordship.
For what you have done, what you have executed.
Lordship, for desiltation of drain lordship.
Okay.
Yes.
Desiltation.
Lordship.
Claiming to have executed by supplying unskilled labor on a higher basis for desiltation of drains under Guwahati Municipal Corporation, the petitioner has prayed for a direction to pay rupees, the direction for release of the outstanding amount of rupees 63 lakhs 12,355 for the above work. List of issue notice returnable by 4 weeks
A brought up for repairing.
for all.
No, Lordship, 1, 2, and 3 for finance, Mr. B. Gogo's name may be recorded.
So and so for so and so.
1, 2,
And
and
B
3.
Gogoi for finance and listing council. So all are represented. Enter appearance so and so so and so. Huh? Extra copies after 4 weeks.
Keep up.
16.
Yes.
The debutor's case, my lord, the petitioner's name appeared in the voter list for the first time in the year 2005, my lord. My lord, but the authority, my lord, put mark 3 before.
There's no case pending.
No, my lord. No case is pending, my lord. Your lordship may kindly have a look to annexure, my lord.
Heard Mr. So and so learned counsel for the petitioner claiming to be wrongly marked as the voter in a for what village Gosaigaon.
My lord.
In the voter list of 2005, in village Gosai Dubi, Hindu Para under 39 number Jaleshwar constituency. Come on, this writ petition is filed. List of issue notice returnable by 4 weeks.
My lord, may I please, my lord.
Yes.
Your lordship may kindly have a look, my lord.
We'll see, we'll examine, we'll see what is there, what is not there.
My lord, one similar situated person approved the court, my lord.
Huh?
My lord, one similar situated person approved this court. My lord, this court was disposed for the my lord. Your lordship may kindly have a look to page 28, my lord. Similar order, my lord. I have
By directing the
Saying what?
SC border to refer the matter to the concerned tribunal, if not already referred.
Next one 9, my lord. Page 28. I have annexed.
Order is annexed also.
Okay, then we'll dispose it of.
My lord.
Consider having considered that the similar matter has been disposed of by this court and as agreed to by the land council for the party. Your name, please.
It's fully
For
appearing on behalf of Mr. Ali for the election commission.
election
Election commission of India.
commissioner
Respondent number
and Mr.
Art Talukdar appearing for respondent number
Then
4.
heard, including him. Then you write that claiming to be so and so, huh? Then you write, as agreed to by the land council for this writ petition is disposed of at the motion stage. Next paragraph. The petitioner claims to be a resident of what? Which place?
My lord, Gusai to be Hindu Para, my lord.
It's a long history. You will use right, huh? The petitioner claims that her grandfather's she was born to Sahir Mandan and Minara Begum. List of the name of the grandfather is Hanifuddin. Late Hanifuddin.
Let Hanif.
Late Hanifuddin, whose name got recorded in the voter list of 1966 under 43 number Bongaigaon Legislative Assembly constituency at village 294 Char CHAR, huh? Under house number 107, serial number 443 of Golfara district. The name of her father is also appeared has also appeared in the voter list of 1979 at village Dakarbita under house number 111, serial number 32 of 39 number Jaleshwar LAC, Legislative Assembly constituency, Jaleshwar Legislative Assembly. The name of the her parents also have also appeared in the voter list of 1997. Also appeared in the voter list of 1997. List of it is contended by the petitioner that she was born and brought up at village Dafkarbita, Lakipur police station of Golpara district in the year 1984. She has also passed class 4 examination in the year 1998. List of the petitioner married to what one Sahir Ali, son of Golapuddin of Gosai Dubi, Indupara, and is a mother of 5 children, permanently now residing after marriage at village Gosai Dubi, Indupara, with her husband and with her family. Mr. After her marriage, the name of the petitioner appeared. The petitioner listed in the voter list of 2000, along with her husband and other family members.
2005, madam.
Huh?
2005.
Yes, 2005. Other family at village Gosai Dubi, Hindupara, under house number 161, serial number 551 of 39, number Jaleshwar constituency, Jaleshwar LA constituency. However, the authority has put D mark in the voter list against her name without any reason and notice to the petitioner. It is the Mr. So-and-so, learned counsel for the petitioner submits that since the name of the petitioner is found recorded in the voter list of 2005, marking D in the with an apostrophe, D will be capital in the voter list of 2005 without any spot verification and providing her the opportunity of being heard to demonstrate that she is not a foreigner. The action of the respondent authorities is not sustainable. It is illegal and arbitrary. Listen. Arbitrary and illegal. You just said. The learned counsel for the respondents have fairly submitted that it appears that the petitioner has not been provided any opportunity of being heard and no due procedure of law has been followed. Therefore, it would be appropriate to refer the matter to the appropriate authority for verification as to whether the petitioner is a citizen of India or not. You just take it from here. Huh? Next parent. Having considered the submission of learned counsel for the parties, and after perusal of the materials available in the court, I find that the D mark has been put against the petitioner in the voter list of 2005 without providing any opportunity to the petitioner. That is 2005, right? Mark in 2005. Enroll in 2005. Enroll as a voter in 2005 and then mark.
Subsequent list also.
Huh?
Subsequently, D is appearing against her name. For the
Which year?
in the last list also, her name appeared as with D, my lord.
Where you have said, where you have.
I have studied, my lord. D appeared for the first time in the year 2005, my lord. Thereafter, in the subsequent list also, my lord, her name has been appearing with D.
Then 2005 and subsequent voter list. You have not specifically mentioned.
My lord, I have mentioned in paragraph, my lord.
Paragraph 6.
Paragraph 6.
My lord.
Where it is, both are pending as well. It is not possible having no where it is.
And in subsequent voter list, my lord.
That's why you have not specifically mentioned the year of voter list. Subsequent only. You just add subsequent. Huh? Then please, in that view of the matter, I am of the considered view that it would be appropriate to direct the matter with that the matter be referred to the appropriate authority. Please do. Accordingly, next para, huh? It is directed the superintendent of police within bracket border. Which place? Golfara. Is respondent number 5. He is respondent number 5. Respondent 5 shall verify as to whether the petitioner has already been referred to concerned foreigners tribunal for adjudication, and upon verification, if it is found that the petitioner has not been referred to the foreigners tribunal, the respondent number 5 shall refer the case to the concerned foreigners tribunal, after proper verification, pertains to the status of the voter against her name at serial number so and so and same, of Jaleshwar LAC in the district of Gwalfara. It is provided that the above exercise shall be done within a period of 2 months from the date of receipt of the certified copy of this order. The petitioner, it is further provided that the petitioner shall participate in adjudication as directed herein above, represent dispose of in terms of above. The order was disposed of.
My lord, the petitioner was born in the year 1984. She was born in.
What I've said, did I say that born in 1894? I said 1984, and she has passed class 4 in 1998. So,
Yeah, please, Lord. My lord, in this case, my lord, matters pertaining to settlement of Sand Mahal, my lord. Petitioner was issued LOI, my lord, page 18, my lord. On 2/11/2004, 24, my lord. And thereafter, petitioner deposited all the monies, my lord, but possession has not.
obtain instruction.
Take instruction. As far as he has, most probably he has not submitted his mining plan, your lordship.
You just take instruction.
Very well, lordship.
If he is defaulted, we'll dismiss the writ petition. All right.
Was a letter of
Heard
intent.
Mr. So-and-so learned counsel for the petitioner. Claiming that the petitioner has not been settled with the claiming for a direction, no, petitioner has wait for a direction to issue letter of intent for settlement of Katakal Sand Mining Contract Unit 1 within bracket capital V bracket in favor of the petitioner. In terms of the order dated 15/03/2024. What I said? No, you just change it, delete it. By filing this writ petition, the petitioner has prayed for a direction to settle Katakal Sand Mining Contract Unit 1B, with the petitioner in terms of the LOI dated 02/11/2024. As per the order dated considering the nature of the issue involved, which pertains to the shifting of shifting of what?
IMFL shop,
IMFL or of
IML off shop.
retail outlet from GNB Road, Silpukri, Guwahati to proposed places at Rani Gate, Azara, Rani Road, Revenue Village, Kahikuchi Moja. This page 22, huh? In prayer person, huh? Moja Dakin Rani, Revenue Circle, Azara District, Kamrup, within Metro Assam. On the ground that such shifting of IMFL of retail outlet oblique the trade of liquor oblique with wine, huh? In the said area would be adversely affect the public at large. The prayer for withdrawal of the writ petition is allowed. List of next accordingly as prayed for. The writ petition is closed on withdrawal with a liberty to approach the appropriate this court in an appropriate jurisdiction for the interest of public. We'll just mention.
Yes, but that will suffice. We oblige. Oblige.
May I please the lordship?
Yes, sir.
My lord, the respondent number 6 was initially awarded with the work of construction of a PMGSY work, my lord.
Yes.
A road under the PMGSY scheme, my lord. A particular construction work was awarded to the respondent number 6. So subsequently, due to delay in execution of the work, my lord, the respondent PWD authorities cancelled the work allotted to the respondent number 6, and by initiating a fresh tender process, the work was allotted to the writ petitioners. Being agreed, my lord, the respondent number 6 approached before the honorable court. This honorable court, by a judgment passed in the writ petition, my lord, has been pleased to hold that, my lord, because the challenge of the respondent number 6 before your lordship was twofold, my lord. One is regarding cancellation of his work order, and second is the award of the remaining portion of work to the petitioner, my lord. So this honorable court has been pleased to hold that the termination of work order in favor of the respondent number 6 is not liable to be interfered with. Accordingly, the respondent number 6 has preferred an appeal before the division bench, which is pending adjudication before the division bench, my lord. So in the meantime, my lord, and in the meantime, the respondent number 2 in the writ appeal and respondent number 3 here, the chief engineer, my lord, he has also filed an affidavit in the writ appeal stating that the remaining work has been executed by the petitioner herein, and it is complete in all respect, my lord. Now, my lord, respondent authorities have issued the orders, my lord, allowing the respondent number 6 to resume the work, my lord. Whereas, my lord, in one stand, my lord, the authorities have stated in the affidavit that it is complete in all respect. And secondly, his termination has been, this court has been pleased to hold that his termination is not liable to be interfered with, my lord. The first termination order, your lordship will find as page 25, my lord. Page 25, the termination order of the respondent number 6, my lord. So when this order was challenged before this honorable court, my lord, this by judgment dated 30/11/2022, my lord, as page 36, the relevant portion your lordship will find as page 54. If your lordship comes to page 54, paragraph number 61. Because in writ petition, there were the two challenges. One is the cancellation of the work with the writ petitioner, and second is the award of the remaining work to the respondent number 6, my lord. So page 54, paragraph 51, relevant portion. In view of the above discussion, this court is of the opinion that while the first challenge pertaining to the termination of contract is not liable to be interfered with, the second aspect, so. So apparently, my lord, the termination order is not liable to be interfered with. That has been held by this by the honorable single judge. So against that, they have filed appeal, which is pending adjudication. No final order has been passed here, my lord. So apparently, as of today, my lord, the termination order is this particular observation is holding the field, my lord.
So
now, my lord, and there is, and subsequently, my lord, the respondent authorities have issued the impugn order. First order, your lordship will find us page 56, annexure 5, my lord. Annexure 5, page 56. If your lordship kindly comes to page 57, my lord, the last paragraph, considering the above, it is by the government to the chief engineer PWD, my lord. Considering the above, I am directed to request you to kindly take the following actions. A, take action against Sri Guljar Hussain Chaudhary. This is that is the petitioner herein, my lord, for his involvement in so-and-so. B, pass necessary order making the work order number dated so-and-so issued to Sri Guljar Hussain Chaudhary for balance work as null and void. C, my lord, take necessary action for completion of the PMGSY package number so-and-so by the original contractor Sri Mansoor Ahmed following due procedure. My lord,
Mansoor Ahmed is respondent number 6.
6 herein and a petitioner in the earlier round of litigation.
Yeah.
So there, my lord, his termination order, because this honorable court has been pleased to hold that his termination order is not liable to be interfered with.
So
And secondly, my lord, the respondent authorities all along in the writ petition as well as in the appeal, my lord, they have filed affidavit stating that the work is complete, my lord. Balance work has been completed by the writ petitioner, my lord. And that finding, your lordship will find at page 99, last page of this petition, my lord. This is an affidavit filed by the chief engineer.
contract was awarded to respondent number 6.
Remaining contract was awarded to the petitioner herein and respondent number 6 herein, my lord.
Remaining work.
Yes, my lord. After termination, my lord.
After termination, you were awarded the
Yes, my
contract,
lord.
remaining amount,
Yes, my
the work.
Yes, my lord.
Then
And my contention is that I have completed the work. And to that effect, my lord, respondent authorities have also filed affidavit. This affidavit at page 91, my lord. Page 91, this is an affidavit filed by the chief engineer, my lord. In the writ appeal pending before the division bench, my lord. Page 91, it starts and relevant portion at page 99. Page 99, my lord. There are 24. That with regard to the statement made in paragraph number 42 of the writ appeal, the deponent states, as per site verification, present status of balance work under PMGSY package number AS 13278 done by the respondent number 6 is found complete in respect. If it is complete, my lord, why it has been again awarded to the respondent number 6, my lord?
so what is your problem? Your job is over. If it is completed, it is completed.
Now, my
What
lord,
do you want? Have you been paid?
No, the entire money.
You
I have
claim
not
for
paid.
that.
No, the entire money.
Whether they award work or not, what is your concern?
Concern is that it is already completed, my lord.
If you have
And
completed, you
secondly,
ask for the payment only.
No,
The
my lord,
works which you have constructed,
Para
I mean,
57
executed.
Page 57, if your lordship looks at by the original contractor Sri Mansoor Ahmed following the due procedure. My lord, once it has been terminated with the Mansoor Ahmed, my lord.
It's
So-
okay. It's his problem. What is your problem? How you are affected?
I am affected because, my lord, if
You are relying on the chief engineer says that the work has been completed by you,
yes, my
what
lord,
is your problem? You claim for your payment, that's all.
I have claimed, my lord, but
What you want in this writ petition? What do you want?
my lord, I pray that, my lord, the respondent may file their response, my lord, and in the meantime, status quo, because, my lord,
First you establish what you want. You just show us what you want. Just tell us.
because assuming that
You have prayed so many prayers. multiple prayers.
No, my lord, only because these four letters.
Which I don't, which I primarily find that you don't deserve even a single, relief. See, you have been allotted remaining work. You have completed. The
Yes,
chief
sir.
engineer said you have completed. Better ends there. You claim, you approach, claim for the payment. Why you are after the the respondent number 6?
That I have completed again, yeah, how it can
So-
be allotted to someone else, my lord.
So, once you have completed the work, matter ends there. You ask for the payment. It's good for you.
And
Whether
secondly,
this is
my lord-
re-allotted,
Secondly, my lord, again, how it can be awarded to the same person with.
what is the problem? What's problem with
If
you?
it has to be awarded, my lord.
How it is
no, no,
affecting
no.
you?
There should be a procedure, my lord. They should issue a fresh tender, my lord. NIT should be there, my lord.
Once you have completed the work, it's
Yes,
the
my lord.
business of the authority.
No, my lord, they are again awarding a work to the respondent number 6, and there should be a procedure followed by to be followed by the respondent authority. Without a procedure, without a tender, how it can be issued awarded to the respondent number 6, my lord?
So why that this award of the work to the respondents, how it is affecting you?
Because it is the
What
same
right has
work
been violated?
I have executed, my lord.
So you have executed, you have completed, matter ends there.
Yes, my lord.
What is your concern?
But how it can be?
We understand there should not be once the work
Yes, my
is
lord, there should
completed.
not be one-
But so how you are affected? Tell us how you are affected, sir. Understand. We could have understood
Yes, my lord.
if if the work which have been entrusted to you or awarded to you have been allotted, re-allotted to respondent number 6 while you are executing. Once you have completed, maybe irregularly, illegally there, how it will affect you? How it will affect you?
The same work is again allotted to the.
So what's the problem with you?
My lord, again, there may be complications there.
What complication? You cannot free.
Because, my lord, the portion that I have
It's
completed,
a-
he will say that he has executed the work. my
it's
lord.
a precautionary writ petition.
No, my lord, because the other,
Please,
he
sir,
will come and he
we are
will
not
say that,
impressed.
he has executed. But otherwise, my lord, how he can be awarded without following the due procedure, my lord?
You file appropriate application for that. First, this is a writ petition, sir.
Yes, my lord. So here I have challenged that, my lord, because, my lord,
First, you have to show that allotment of the work to
Yes.
the respondent number 6 has affected you.
the same very work that I have executed, my lord.
You have executed, you have completed.
Yes,
Have you
my lord.
not?
Yes, my lord.
Have you not completed?
Yes, my lord, I have completed.
Matter ends there.
But
You
there will
don't
be again further dispute, my lord.
So,
Because now.
that's why I'm saying you cannot file a precautionary. There is no
So it is
concept of
now, my
precautionary
lord,
precautionary
we have
writ petition.
to resume the work.
First, you have to establish that your fundamental right and the legal rights has been affected by the action of the state.
Yes, my lord, because now my payment has not been cleared, my lord.
That's a
So
different issue. You
what
file
they-
for that. You file a writ petition for that.
That day, my lord, the respondent number 6 will come and he will again pay for the payment.
Sorry, sir. We'll list after some time. First day, I don't want to dismiss. Next week, think over it.
Yes, my lord, next week.
Heard Mr. Swain, so
Or on Friday, my lord.
on Friday.
Yes,
You
Lord.
think over it.
No, let it be on Monday. Let
Monday.
Friday have some.
Monday.
Monday, my lord.
But I'm a
Prima
very-
facie, not prima facie. I'm not convinced, and I'm not inclined to even issue a notice.
Yes, my lord, on Monday, my lord.
Monday.
Yes.
Look, let them give me a copy of the petition. I am for respondent number 6. Well, many things have not been said, Milord. Anyway, let my
No, I think, sir, that's why even though you are appearing, it doesn't record your presence, and we don't like to hear you. I have heard him. We were listing it for only withdrawal on Monday.
Yes.
Oh, my lord, for motion, my lord, then I could.
No, we listed in motion,
Yes.
but I find it's not.
Yes.
Cannot encourage.
Deeply.
Yes, my lord.
You know, I understand,
Yes,
but
my
at the same time, you have to understand us also.
Yes.
Reciprocation.
Oblige, my lord.
Yes, wait for Land Council, Mr. DP Bora. Let this matter be listed on Monday, listed on so and so. as in motion item, in a motion clause. 21, yes. Yes.
Hello, the petitioner is a partnership firm who deals in contractual works. In
Yes.
various departments, Your Lordship.
Yes.
In the year 2023, one e-tender has been advertised by the respondent number 2, APGCL, for construction of the various development works at Lakua Thermal Power Station, Your Lordship, that's Soraideo. The works are your Lordship, development of boundary walls around the Lakua Thermal Power Station colony, repairing of administrative office building of LTPS, construction of paver block road from the main road in front of the army canteen to the newly constructed multi-story building.
It's okay. Where is this imposition? Is there any order imposing liquidated damage?
Yes.
Where is the order?
There was no any order, Your Lordship, there was no any order. However, at the time of, after completion of the said tender.
At the time of payment?
Yes, Lordship.
This
They
has
have
been deducted?
Yes.
Okay.
Security damage, Your Lordship.
Is your issue notice, let us see.
Yes, Lordship. Yes.
Heard Mr. So-and-so learned counsel for the petitioner. By filing this writ petition, the petitioner has prayed for a release, prayed for release of an amount of rupees, what, 7 lakhs?
7 lakhs, 10,000.
10,000, 15.85, which has been deducted as liquidated damage along with interest at the rate of 12% per annum from the date of deduction till realization. Please stop. Next, it is the contention of the petitioner that the respondent authorities have arbitrarily imposed liquidated damage at the maximum ceiling limit of 10% of the contract value without any proof of assessment of actual loss and in violation of Section 74 of Indian Contract Act. And the same has been done without affording an opportunity of hearing to the petitioner. Issue notice returnable by
I am appearing
4
for,
weeks.
appearing for respondent number 2, 3, and 5. No?
Yes. And who else? So all are represented.
4 is CGM of our company, but he is banned. The notice has to go
By name.
by name.
Okay. Since Mr. Dinat
Lot.
is a standing counsel,
Standing counsel,
standing counsel
APGCL.
APGCL
2, 3, and 5.
For enters appearance on behalf of respondent number 2, 3, and 5, and Mr. I'm telling that for standing counsel, and GS, district council for state of Assam for respondent number 1 enters appearance so and so, no formal notice needed. However, extra copy in finance. Petitioners to take a state for service and notice upon respondent number 4 by registered for so and so.
Lordship, my lord, I would humbly submit. The question of maintainability of this petition may be kept open.
Okay.
But in my respectful submission, there is an arbitration clause in the contract. So that may be kept open.
Mr. Dinat, learned counsel to the learned standing counsel submits that the present writ petition, the writ petition would not be maintainable in view of the existence of arbitration clause in the contract agreement. Having considered the submission, I deem it appropriate. No, the issue of maintainability is raised by Mr. Nath shall be considered on the next returnable date.
Yes. Lordship, returnable in 4 weeks.
4 weeks.
Lordship, online.
Wait, please, Your Lordship.
Yes, sir.
My lord, the present petition has been filed challenging the illegal collection by the railway authorities for on account of penal damage charges and
Yes.
terminal charges, my lord.
Okay.
There is a mandatory circular, my lord, that a 48-hour prior notice and wide publicity has to be.
And Mr. So-and-so will issue notice.
My lord.
The petition is not maintainable, my lord. Because there is an alternative forum, RCT, my lord judgment. My lord itself has passed the judgment, my lord, that it is the railway claims tribunal where the application would lie. So there is an alternative remedy, my lord.
My lord, the facts of the present, the
Paragraph,
judgment.
my lord, 17 onwards, my lord. Section 13, my lord has quoted, which deals with jurisdiction of the railway claims tribunal. Thereafter, my lord, paragraph 18, which deals with section 36. 36 of the Railways Act provides for complaints against railway administration. It provides that any complaint that railway administration is contravening the provisions of section 70 is charging for the carriage of any commodity between the two stations at a rate which is unreasonable.
It's okay.
Third one.
Have you-
My lord, I have already gone through this judgment, my lord. The facts of this case and the facts of my case is totally different and not applicable, my lord. And my lord, Honorable Apex Court, in the judgment which I made, my lord, in pertains to railways matter only, have held that a writ jurisdiction is maintainable, even if there is an alternative remedy of appeal available.
Lord, penal damage charges, my lord, same issue, my lord.
Lordship may issue notice, lordship terminal charge is also there.
My lord.
We'll say in that case, we'll issue notice, we'll keep the issue of maintainability open. We'll consider on the next day.
Lord, we'll record this judgment, my lord, because it's
It's
my lord's
okay.
judgment.
It's okay. He's trying to distinguish. Let us provide him an opportunity. We'll decide.
Notice.
We'll decide the matter on the next date, on the returnable date.
Supply him the judgment, my lord will fix it on a short date, my lord.
My lord, if 48 hours prior notice and a wide publicity has not been done, then my claim is not maintainable. I am admitting to the fact. But however, my lord,
Same issue, my lord, here, my lord will see paragraph
there
26.
is disputed question of fact. The
Paragraph 26, my lord, the issue which my learned friend has raised, 48-hour notice. Paragraph 26, my lord has dealt with it. In the present case, although the learned standing council has submitted to the Fishery conflicts place for notice of all concern, wherein it was stated to give 48-hour notice, the same appears to be not in.
No, we'll
Same issue.
sir, we'll determine it after 2 weeks. You find out factually also what he claims. But your maintainability should be considered on the next day. We'll make it returnable.
He has jurisdiction.
Yes.
Claims he has not. Why
Let
is
them file affidavit, my lord.
my lord?
Let them file affidavit. Notice may be issued at this stage. I'll file in response,
He is
my lord.
wasting his time also, fourth time also. He could have approached RCT, my lord, by now he would have got the relief.
My lord, in this judgment of the Honorable Apex Court, the Honorable Apex Court in paragraph, if your lordship may look upon paragraph 4 of the judgment of the Honorable Apex Court, herein it is expressly stated by the Honorable Apex Court that a writ petition is maintainable, even if there is a jurisdiction of the railway claims tribunal, my lord, available.
Very
My lord's
clear.
judgment,
It's a
my lord,
railway,
the same
my
issue.
lord, railway matter, my lord.
Those writ petitions were dismissed, suggesting writ petition that the alternate remedy lay in the form is to the challenging was
Paragraph 4 is
question raised by
relevant.
press. Stand in legal which required insurance to This is what?
This, my lord, this case pertains to railway matter only, my lord. Seeking compensation for damages, my lord. In paragraph 4, my lord, it is stated, in the present case, between 4th March 1992 and 31st December.
Where it is?
Paragraph 4, my lord.
Huh?
Paragraph 4.
Paragraph 4 is leave granted. Union of India and State of Haryana.
Apology, my lord. There is another judgment. Apology. Para 4, my lord. In the present case, between 4th March 1992 and 31st December 1992, the appellant has booked rakes for carrying coal to Gurla, a sum of rupees so and so, which has been collected from the appellant over a period of time by mistake. That the mistake has been committed is admitted by the respondent herein, and it has duly noted by the High Court. However, the High Court, in our view, erroneously rejected the claim on the ground of availability of alternative remedy. On the aforesaid premises, the High Court dismissed the writ petition with the direction to the appellant to approach the Railway Claims Tribunal for alternative remedy available under Section 13 of the Act. We are clearly of the view, as the respondent, Union of India, has clearly admitted the liability. The High Court ought not have relegated.
See, this is a case, this is distinguishable.
Different case.
This is a case where the mistake, by mistake, they have, respondent has collected and it has been admitted.
My lord.
In view of the admission only, it need not be relegated to the tribunal.
Yes.
This is a dispute whether your, the charges, demurrage charges, and the penal demurrage charges in accordance with law and all.
That's it, my lord.
What, that has to be by the, this can be decided by the appellate authority under the Act. Here is a case, they have admitted, respondent, that by mistake it was collected or imposed. Therefore, there nothing remains.
My
They-
lord, let them file an affidavit, my
Paragraph
lord.
29
If they are denying, my lord,
Lord,
that
if
case-
you paragraph 29.
We'll see
Paragraph 29.
after a week.
My lord.
After a week. Heard Mr. So-and-so, learned counsel for the petitioner. You find out some more judgment. This is distinguishable.
No, but
Clearly.
He has not.
This is
annexed-
clearly distinguishable.
He has not annexed the order by which he has been
Anyway,
charged. That order is also not.
we're not issuing notice.
Okay, my lord.
You
DCP
just serve a copy to him.
Yes, ma'am.
Where it's not issuing notice, we'll just
I'll give that,
is-
ma'am.
ask him to the obtain the instruction. All right.
My
Challenge made in this writ petition is to the collection of imposition of
imposition of penal damage.
penal demurrage charge and
And terminal
terminal charges by the respondent's railway authorities, which has already been collected from the petitioner. Next para. It is the contention of the petitioner that the requirement of issuance of 48 hours prior notice and conducting public wide publicity of the said notice has not been complied with by the respondent authorities. List of next para. Mr. Gupta. Why Gupta?
H. Gupta, ma'am.
H. Gupta, London Standing Counsel,
PGC, my lord.
London CJC. By referring to the section what? What is the provision?
Section 36C, my lord.
Section 36C of the
Railways Act.
Railway Tribunals Act.
Yes, my lord.
Railway Tribunals Act 1987. Submits that the writ petition.
1989, my lord.
And 1980
Railways Act 1989.
Railways Act 1989.
Yes, my lord.
Submits that the present writ petition is not maintainable as there exists an alternative efficacious remedy available under the law. Please stop. Having considered the submissions of learned counsel for the parties and also perusal of the order of the Honorable Supreme Court as well as by this court, let this matter be listed after a week for determination of the maintainability of the writ petition. List of the respondent authorities. And then Mr. Gupta, then it's CJC to obtain instruction in the matter on merit. List after a week.
My lord, I have just one submission, my lord. If the instruction may be taken in regard to whether 48 hours.
No, you have raised the legal issue.
My lord,
This
it
is
may not be
the
issued.
imposition of the demurrage charges is without issuing a notice, 48 hours notice
My lord,
and word publicity. That's all.
that's it. And collection of terminal
Whether-
charges is illegal, my lord.
Whether
That's all.
that can be raised and can be a matter of adjudication by the appellate authority, that we'll see.
My lord, much obliged. 23.
Should complete before 1 o'clock.
Yeah, please.
Yes,
Matter pertains to my lord admitted real amounts, my lord.
yes, how much?
My lord, 3,97,433. 3,97,433.
By filing this writ petition, the petitioner has prayed for a direction to release the outstanding bill amount of rupees 3,97,433.50 paise, huh?
A
For
representation
the
was made, your lordship.
for
as an
the
extra-
just wait for the supply of
Stationery
materials to the government in the form of what?
to the, my lord,
For the
admitted
supply of stationery materials, huh? As well as computer and its accessories to the office of the Director of Secondary Education, Government of Assam. Police Chief, issue notice,
Yes, sir.
issue notice, returnable by so and so, huh? As MS so and so, learned council,
Yes.
P. Das, State Council.
I'm appearing for secondary education, that is respondent number
Standing-
1, 2, and 3.
Who else are appearing?
1, 2, 3.
Standing Council for Secondary Education and so enters appearance and accept notice on behalf of all the rest no formal notice means however extra copies and so, huh?
I'm
My
deeply
lord,
obliged.
this matter may
4
come up-
weeks.
This matter may
4
come up
weeks.
along with my lord.
4 weeks.
No, my lord,
Ah.
that is right, my lord. This matter may come up, my lord, along with WPC number 4730.
On the prayer of the learned council for the petitioner, list this matter along with
Public 2025.
WPC
4730.
4730 of
5.
25, huh?
I didn't get my.
You take note of that, take instruction for
Yes,
that
sir.
also.
I'm deeply obliged.
1924.
Please, your lordship.
Yes.
This is a devoted matter, lordship.
Yes,
The father of the petitioner, Nizamuddin, he is a junior engineer. He is a joined his service. The petitioner was first his cast vote at the village lordship Bannaguri under number 39 Joleshwar LAC. After that, the petitioner was married 1991 one Mathiur Rahman, but without her knowledge, her name was recorded and her husband village lordship. And 1997 first time her D is recorded her name against her name lordship, which was page number lordship. Page number 34, lordship. So, lordship, after that, he approached the concerned authority to remove the D lordship, but no action taken place till date, lordship. So he is not.
yes,
And similar judgment, dear lordship.
yes.
May it please your lordship. Lordship, I am appearing for respondent number 3,
Yeah.
Election Commission. Your lordship, actually, this kind of matters have been actually disposed of by a coordinate bench with specific directions. If your lordship,
Yes, heard so and so, learned counsel for the petitioner, and MS so and so, huh? challenge made in this writ petition is to the marking of the voter of the petitioner in respect of Shariatpur number 44 Jania LAC under district Barpeta, Assam for the year 1997 onwards. List of disposed of.
Yes.
There's with that dictated one method with Miss Victoria. It is something.
The petitioner can approach SP border.
Yes, we'll give a direction. Similar order will be passed. We have disposed of one matter. I think 17, item 17 or 18?
Obliged.
You just 15.
16, yeah.
16, yes. Teheba Bibi, huh? Then you share with Victoria, huh? Ask her to go to.
Obliged, Your Lordship.
Same order will direct the SP to verify.
Yes, look into.
And you have to cooperate with the authorities
Much
for
obliged.
all this adjudication.
Obliged, Your.
Dispose of. This is dispose of. 24. Victor. Yes.
Lordship, appeal was preferred against the against the order passed by the Registrar of Trade Union, whereby the Registrar of Trade Union denied the registration of the trade union. The appeal is dismissed on citing a wrong provision of the law. Lordship will find the order last or impugned order is on page number. Lordship 52. And let's start from 53. I may be allowed to read. It's a very small order, Lordship. This appeal under section 11.
Where it is? Page
53.
53. Yes.
This appeal under section 11 subsection 1 within bracket AA of the Trade Union Act 1926 has been preferred by the appellant against the order of Labour Commissioner. On the receipt of the appeal memo, notice was issued. Lordship, I'm coming to the main person, the paragraph number 4. The case of the appeal.
Heard Mr. So-and-so will issue notice. Learned counsel for the petitioner. Challenge made in this writ petition is to the judgment and order dated. Judgment dated,
Lordship, page number 52.
Judgment dated 6/06/2025, passed by the Labour Court, Kamrup within bracket M, bracket close, Guwahati, Weber. The appeal,
Yes, Lordship. Appeal under Trade Union Act.
Appeal under section 11 within bracket 1, bracket close, bracket small double A, bracket close of the Trade Union Act 1926 has been dismissed against the order of the Labour Commissioner or Labour Court.
Labour Commissioner. The appeal was preferred against the
Labour
order
Commissioner
by the Labour Commissioner,
has
who
been
is the Registrar of Trade
has
Union
been
also.
dismissed. It is the contention of the petitioner that the learned Labour Court has wrongly applied the while dismissing the appeal of the petitioner, the London Level Court has wrongly applied the provisions of law. List of issue notice returnable by 4 weeks. Who else? Who is the respondents? You cannot.
The government can receive lordship the labor.
Register of Trade Union, I said.
Register itself a labor commission.
Counsel for the petitioners to take steps for service of notice upon respond by register for service.
Lordship, the
Within 2 days.
Lordship,
We'll see. First, you take steps.
I'll take lordship. In the next date, lordship may call the record also.
Next date we'll call. We'll see.
26.
May I please, the lordship?
Yes.
Regarding lordship, electricity connection lordship. Electricity connection lordship. And what happened in this case, lordship? The lordship may kindly see page 3, lordship, paragraph 2, lordship. These are my lordship, my consumer numbers, lordship. Unfortunately, lordship, I have received the letter, lordship, from the subdivision.
Where it is?
Letter, lordship.
You're challenging that letter.
Lordship.
Where it is? Where is the letter?
At Annex 2, lordship, page 12. Page 12, lordship.
Payment of outstanding electricity bill amount.
Not my consumer number, lordship.
It's not your consumer.
No, not lordship. My consumer number is different.
Its area is what?
Lordship,
You are Anil Kumar Hazrika?
I am Anil Kumar Hazarika.
Pranab Hazrika?
Pranab Hazarika is my brother, lordship.
AK Hazrika?
AK Hazarika, Anil Kumar Hazarika, lordship. And we are two brothers, lordship.
So?
And that electricity connection is in the name of Prabhat Chandra Hazarika, lordship. It's a different person, neighbor, lordship.
Pranab
Prabhat Chandra Hazarika, lordship.
It may be a mistake.
Lordship, by mistake.
Consumer thing may be mistake, but the amount may be correct.
Lordship.
Outstanding amount may be
Not
correct.
correct, lordship. I have given my.
Heard Mr. So-and-so, London Council for the petition. You obtain instruction.
Yes, my lord.
Please stop.
He does, my lord.
The petitioner challenges the communication dated 21/09/2023. This is 2023.
Yes, my lord.
Whereby issued by the subdivisional engineer Nagaon ESD-1 APDCL CAR Naga,
Submitted representation, lordship. That was not.
whereby the petitioner has been intimated about the huge outstanding electricity bill amount against the electricity service connection in his name / premises bearing consumer number page 12 12200001315 amounting to rupees 18 lakhs.
1,80,770.
1,80,717 up to August 2023. Stop. It is the contention of the petitioner that the petitioners,
Petitioners.
Petitioners,
Yes.
the petitioners are having a service connection, electricity service connection in their names having consumer number 1220100444819 and 12201004910. Whereas the impugn intimation of his outstanding amount of electricity bill
Lordship, we filed a representative
is
page 16, lordship.
in the name of different is in some other's name list of next paragraph, considering the nature of the issue raised, and And also that the matter relates to the year 2023, Mr. So-and-so, Midas Learned Counsel for APDCL
Response number two.
to obtain instruction. APDCL, you have issued, APDCL has issued the notice.
Two is the application, one is the government.
Okay. Government, who will obtain the instructions? You. So and so is also. Is it? Next.
2 weeks.
After 2 weeks.
Apply.
Yes.
Lordship, here petitioner has supplied the materials for construction of raised platform, my lord. 15 lakhs 5,200 339, my lord. The amount, the supply order pays 37. Then, my lord, the amount has been duly passed by the concerned BDO.
Sir.
That is pays, my lord, 41 onwards.
You are seeking for release of payment of this amount.
My lord, this amount.
Heard Mr. So-and-so learned counsel for the petitioner. Next paragraph, by filing this writ petition, the petitioner has prayed for a release of an outstanding amount of rupees 15 lakhs 56,419 for the supply of materials for a construction of raised platform work at Niloka PT Roman 5 of Mohiri Char Gaon Panchayat under MGNRE Manrega, MGNREGA scheme for the year 2023. Issue notice returnable for 4 weeks, so and so. And so and so. Both of you are representing all the respondents. It has appearance, so and so, extra copies. Yes.
My lord, tendency, my lord, will not be bad.
No, it's okay. We'll see. Since you are issuing notice, we'll see.
My lord, then matter may be listed, my lord, along with WBC number.
As prayed for by the learned counsel of the petitioner, list this matter along with WPC
4777
4777
of 2025.
2024. Yes.
PTA. I am the.
Notice may be issued, madam.
Yes.
Non-payment of bill of vehicles, madam.
Heard Mr. So-and-so as per the learned counsel of the petitioner. Matter pertains to claim for payment of amount of rupees, outstanding amount of rupees 35 lakhs,
Yes, madam.
8,849 on account of hire of the vehicles by the respondents for a period of any period, specific period.
First one is my 22/10/21 till today, madam. It is not requisite. Now, second one is, madam, from 1/7/2020.
It's okay, then it's okay.
It's in service, madam.
Issue notice, so and so, learn as so and so, huh? Extra copies. Are you getting? Are you getting same, almost same order?
29.
Yes.
I'll be paying for a notice only. The
Yes.
tender was issued. With condition, your lordship will get it at page 27A. 27D, madam. Mandar Desa gate, a vehicle gate. It starts from page 27. And conditions are, my lord, condition number 2, 4, and 7. 4 says, my lord, once you are selected, my lord, you will have to pay the whole amount, the quoted amount. Now, if they fail to pay the quoted amount, the next, my lord, person, he gets a chance, according to clause number 7. So petitioner.
So there's according to the clauses of the terms and condition of the tender has been violated while settling with the respondent number 7.
Respondent number 7.
Therefore, since with the next highest bidder, you should be considered. And Mr. BD
deposited the quoted amount.
BD does learned senior counsel assisted by Mr. So-and-so, land counsel for the petitioner. By filing this writ petition, next para, the petitioner, as per for a direction, to set aside the order of settlement that is 080, no.
Yes, that is.
By filing this writ petition, the petitioner has challenged the order of settlement that is 0805/2025 issued in favor of the respondent number 7 on the ground that on the ground that the respondent number 7 has not furnished, has not deposited
The quoted amount, bid
the
amount.
quoted amount in terms of the
Clause 4.
clause 4 of the tender conditions of the tender dated. What is the tender?
Tender is dated.
No,
by
the
the
notice dated 26/03/2025.
20.
Yet settlement order dated settlement of you just right now. When I said settlement of the Mandir Disha, na?
Yes.
Vehicle entry gate. Dated, 0805. You write like that.
By 32, page 32.
Page 32. You just page 32. Petitioner also prayed for settlement of the said Mandirsa vehicle entry gate in terms of tender condition number 7 to the writ petitioner being the next highest bidder. Highest bidder.
Yes, next valid.
Next
bid.
valid highest bidder. List of issue notice returnable for which you are appearing for all.
Respondent number 1 to 6 official respondents also.
Then who is okay?
Private
As Mr. So-and-so, land counsel for the petition appears on behalf of respondent number 1 to 6, no formal notice need be served. However, extra copies, Good. Petitioners to take steps for service of notice upon respondent number 7.
7, 8, and 9, madam.
7, 8, and 9.
And we'll take Dusty also.
By registered post as well as by dusty mode within 7 days.
Yes.
List after 4 weeks.
Okay.
We said no, 3 weeks, 4 weeks. Issue not returnable, but issue notice return 4 weeks.
Can it be 3 weeks, madam? They can just break
Okay,
it.
then 3 weeks. 3 weeks.
The date can be given, madam.
Yes. Yes.
My lord, by virtue of this writ petition, my lord, basically we are challenging the action of the respondent to reject my bid on technical grounds, my lord.
Where it is, where is the rejection?
My lord, rejection your lordship will find at 166, my lord. Relevant page is 170.
170.
170, my lord, in serial.
Well, issue notice, that's all.
My lord, in
LOIs have been issued, madam.
Huh?
LOIs have already been.
We'll see on next day. It's a rejection of technical bid.
rejection of technical.
I heard Mr. So-and-so learned counsel for the petitioner.
My lord,
By filing this writ petition, the petitioner has put to challenge the rejection of his
at page 170, my lord, at serial number 125. My
170.
page 170, my lord. Serial number 125 is my name, my lord. Let us run it.
170. 125, yes.
Serial number 125 is the petitioner, my lord.
Rejection of the technical bid,
Yes, my lord, technical bid.
Put to challenge the rejection of the technical bid of the petitioner. By this in evaluation or what?
Yes, technical bid evaluation, my lord.
With evaluation dated?
My lord, that was done on, the result was published on 21st July, my lord.
21/07/2025. Pursuant to the NIT dated 03/03/2025 for bulk LPG transportation contract by road for the state of Manipur. Is it?
Yes,
Why this has been filed here?
my lord, because the head office is
NIT was here.
Yes.
Okay.
Here and office is here.
Okay. issue notice returnable by 4 weeks. As Mr. So-and-so, you're appearing for all
Yes, all the respondents.
so-and-so. Then-
My lord, respondents 2 to 5, man.
My lord, one is central government, my lord, and 2 to 5, he is appearing for 2 to 5.
2 to 5, no formal notice need be served. However, extra copy.
My lord, in similar method, my lord, an interim order was passed, my lord, at para 10, my lord. I pray for similar, my lord.
That is the
And
order,
the
my lord.
petitioners to take a stage for service of notice upon respondent number 1 as no non is represented.
My lord, if your lordships come to para 10, my lord. My lord, that was a matter.
What is this? According to this code, therefore directs this one not to grant continuation 2 trucks. No, this is something different.
It's different, my lord.
My lord, I pray, my lord, if they have not
Petitioner have
issued
been
the-
able to make out a case for ground certain in the court further takes note of that if all the trucks for which the tender's plot is allotted to others, the issue raised by the petitioner who discloses.
In this case, LOI has already been issued.
Ah.
The requirements are met. So this was prior. And this is
Correct,
different.
my lord, that, I'm not disputing that, my lord. My lord, if they have not issued the entire LOI, my lord, 2 spots may be kept vacant, my lord. That is my humble prayer, that may be observed. If they have not issued the entire LOI for the 7 empty trucks, my lord, then in that event, my lord, 2 spots may be kept vacant, my lord.
My lord,
If it's not already
If it has not already, my lord,
allotted.
my lord, then
my
only 2
submission may be recorded. This has already been done because evaluation is already complete and the LOIs are already on.
If there's some vacancies, there are 2 spots may be kept.
I will still may be given the liberty to consider
Yes,
adjustment against a possible exigencies requirement.
Yes, my lord, that will do, my lord.
Heard on interim prayer. And next para. Consider the submissions of learned counsel for the respondents that the LOI has already been issued
For 316 trucks.
for 316 trucks, huh? And also considering that the submissions of learned counsel for the petitioner that if there exists still a
If there is still, yes, vacancy, my lord, if they have not completed the LOI process, fully allotted.
exists a vacancy.
Yes, then it may be kept reserved for us.
Same may be kept preserved till the returnable date,
Correct, my lord.
comma. If all is, what do you call?
If all the requirements are not met.
If all the requirements are not met as on today, comma, the respondent authorities may kept 2 what?
2 trucks, my lord, two trucks.
2 trucks.
My lord may not take 2 vacancies. My lord may allows the liberty to adjust, accommodate them against exigent requirements.
Yes, my lord, that will also do, my lord.
Okay,
That will also
the respondent are directed to
Given the liberty to adjust,
are given liberty to adjust,
accommodate,
accommodate
against future exigent requirements.
against future
Exigent
No, my
requirements.
lord, future will be too vague, my lord. They will
existing
against the
requirement.
existing, my lord, against the existing.
Existing my lord is already.
If
my
that's
lord,
why if there is a vacancy, huh? Future will not say if there is a vacancy as on today,
As on today, my lord.
as it stands today.
Yes, my
we'll
lord.
say.
That will do. Highly obliged, your lord.
Supplementary post is order extinguishment of party item 53 connected.
Episode also.
Yes.
I'm praying for improvement this matter.
Hmm.
The concerned setting aside of a consent to establish
Hmm.
a brick in industry. I am still related on 2 dependents. An elephant conflict going on in the village. And in fact, there is a NGT ordered inquiry on the same unit. So I'm seeking to place those facts on record.
This is the repetition is by the
owner.
By the owner of the brick kiln, my lord.
brick kiln.
In fact, my lord, petitioner is agreed by the withdrawal order of the by the
Public, the pollution control
Yes,
board.
my lord. My lord, pollution control board is never attending, my lord. Last occasion also, my lord.
Do you have any objection?
My lord,
Well,
in fact, he has already raised his grievance before the NGT, my lord. That is going on. In fact, it is written in the IA also, my lord. So, my lord, I don't know, my lord, how he is affected, my lord, if the even, my lord, the brick kiln is not yet started, my lord. It's just construction was going on, my lord. And at the end of the construction, my lord, that was
It's okay, we'll give them, provide them opportunity, whatever they want to say, because they'll be affected. You are the residents of the locality.
Yes, sir. I am not the petitioner before the NGT. It is another villager. I am seeking to place it on
It's okay, what's there?
my lord, that is not a problem, my lord. But the problem is that how his right is affected. My lord, not the
No,
brick kiln is
they
not
may
yet
not,
started, my lord.
they may not like to come up your brick kiln in their locality. It may have a effect on the their health and all those things.
Normally, my
If
lord,
it is not the properly
normally,
managed by the.
what happened, my lord, when a brick kiln application is for brick kiln,
It's okay, only here.
My
It's
lord,
not
my
that. Even if they are there,
my lord,
if you have the thing, if you have the merit, you'll
my lord,
you'll get the relief. Don't worry. We'll just all right.
well, only matter is that, my lord, matter will be fixed on next week, my lord.
Huh?
Because matter will be fixed on next week, my lord.
Why?
Because, my lord, the brick kiln, my lord.
Pleadings complete or what?
Yes, my lord. They are pollution control board main grievance is against the pollution control board, my lord. They are not responding, my lord.
Who is for the pollution control board?
As Burua is there.
You inform him. We'll take it after 2 weeks. No, have they filed their response?
No, not yet, my lord.
Stop, no use fixing. Anyway,
My lord, it is
heard Mr.
Yes,
So and so, learned counsel for the petitioner,
applicant.
applicant, and also heard Mr.
Yes, sir.
learned counsel for the petitioner, opposite party writ petitioner, right?
Right.
By filing this application, the applicant has prayed for implement applicants. How many? Two applicants. Filing this application, the applicants have prayed for implement in the connected writ petition being WPC 1409 of 2025.
As respondent number 10 and 11.
As respondent number 10 and 11. List of next paragraph. The petitioners, applicants claims to be the residents of what? Residents of
Village Chengnoi, Lordship, paragraph.
village Chengnoi, where the brick kiln of the opposite party writ petitioner is proposed to be established. Mr. The consent of the consent given by the Pollution Control Board.
Consent to establishment.
Huh?
Consent to establishment.
Consent to establish the brick kiln
Was withdrawn.
has been withdrawn by the Pollution Control Board, Assam. Consent to establish brick kiln of the petitioner has been withdrawn by the Pollution Control Board Assam, which is a subject matter of challenge in the above connected writ petition. Mr. The petitioner further claims that the applicants further claims that they would be the affected persons as the brick kiln which is proposed to be established is located in the vicinity of their residence. Therefore, submits that they are necessary parties. Having considered the submissions and also considered that also considering that the petitioners applicants are the residents of the above area where the bleak kiln of the petitioner is proposed to be set up. And if the requisite provisions for control of the pollution is not taken, the applicants and other residents in the locality may be affected. And also as well as the prayer for implement not being objected to by learned counsel for the opposite party, writ petition, I deem it appropriate to allow this application. Stuff accordingly. The applicants be implemented as party response number 10 and 11 in the connected WPC 1409 of 2025 as the applicants are the necessary parties. List of the interclear application accordingly stands allowed and disposed of. In this petition, in view of the order passed in IA so and so, the petition is to file amended cause title. List of and the registry to incorporate the newly implemented respondents number 10 and 11.
And can be fixed on 9th of September.
You have the writ petition. You have the writ petition.
Yes.
As the newly implemented respondents have already received the copy of the writ petition along with the annexures. No formal notice need be served. List the matter after 3 weeks.
9th of September, my lord.
Why?
Because as you see there, my lord, because the entire investment is, my lord, retail, my lord.
List the matter. Spread for list the matter on 9/9/2025.
In the meantime, they can file their affidavit. Right.
This one, and it will be 1946.
May I say the lordship? Lordship, this IA is filed for implement of the applicant as party to petition, lordship.
You are the writ petitioner.
No, lordship, I am the applicant, lordship, for implement of my
Who is for the writ petitioner?
petitioner.
Who is for writ petitioner?
The petition is item number 46, lordship.
K. Borua, have you served the notice, a copy?
Yes, lordship. And they were in the morning, lordship. Mention the matter.
Who are you? Why you want to be implemented?
Lordship, in this case, what happened that tender was issued on 27/6/2025, lordship. And technical bid was opened on 21/7/2025. In the technical bid, lordship, the petitioner bid was rejected. Thereafter, on 7/8/2025, lordship, the financial bid was opened and the petitioner was selected for awarding the contract, lordship. And in 12.
Petitioner or applicant?
Applicant, sorry, applicant.
Applicant.
And lordship, page 9, annexure A, lordship.
No, problem is no issue, but what about the petitioner? Where is petitioner? Have you informed?
Lordship.
We'll take after some time, you kindly inform. Right?
Lordship.
Kindly inform.
Item
46.
Yes, sir.
Yes. Any objection?
No objection.
Okay, then. Heard MS so and so and counsel for the petitioner. applicant and also MS so-and-so, counsel to opposite party, writ petitioner. Petitioner, by filing this application, the applicant has prayed for implement as respondents. Respondent number 4. Respondent number 4 in the connected WPC 4627 of 2025. Next para. The writ petitioner has challenged the rejection of its technical bid pursuant to the what? NIT?
NIT dated 26/7, 27/6.
26/7?
Sorry, Lordship, 27/6.
27/6/2025.
25.
For what?
Lordship, for appointment of handling and transport contractor
For appointment as the handling and transport contractor.
for transportation of food grains under National Food Safety
Transport,
Act.
handling and transportation of food grain items
Yes, Lordship.
in respect of Vishwanath district for both Tier 1 and Tier 2. Plus the applicant submits the applicant, the bid of the applicant has been found responsive even in the financial bid evaluation. You have been given the thing?
Yes, Lordship.
And the
Annex A page 9, Lordship. On 12/8/25.
page?
Page 9, Lordship. Before they approach this honorable court, Lordship, by challenging the technical base, they have suppressed this fact, Lordship. The contract has already been awarded.
And the contract has been, no, what I say? And by the order dated 12/08/2025, the applicant has been awarded the contract, above contract pursuant to the NIT dated so-and-so, huh? Mr. Having considered that the petitioner, the applicant has been awarded the contract pursuant to the NIT dated so-and-so, and the challenge made in the connected writ petition is to the rejection of technical bid of the opposite party of the writ petition, I'm of the view that the applicant is a necessary party in the connected proceedings. Mr.
Lordship, before filing of the petition, Lordship, this award was contract was awarded.
Please,
and they have
just
suppressed
wait,
this
just
fact,
wait.
Lordship.
It would be appropriate
Now,
to allow
please,
this application to and to implement the applicant as respondent in the connected writ petition. Accordingly, writ petition, the applicant is allowed to be implemented as respondent number 4 in the connected writ petition, being so-and-so, writ petition number so-and-so. The integral application is allowed accordingly, allowed and disposed of in writ petition in view of the order passed so-and-so, same, you file this so-and-so. You have to file amended cause title and the registry to incorporate the newly implemented respondent number 4.
Lordship, we have also filed a IA, including all the other bidders as well as them. So that may be kindly listed day after tomorrow.
Okay. Why others? It has been rewarded to her. Others it's not required. If they are agree, they have not been awarded. They are all out now, subsequently. It's not required, just Anyway, if you want to implement them, it's okay. It will be listed. Hmm. In view of the order passed, so and so, so and so. List will see. When it is to be listed again?
Lordship, we have filed it yesterday.
No, this writ petition is to be
It
when?
was supposed to be listed today. It is listed today as item 46.
Okay, next. When do you want to be listed?
After 2 weeks or one?
2
Any
weeks.
court's convenience.
You may, if you want to, if you wanted the any modification of the interim order, you may file appropriate application.
Nice, Lordship.
Yes.
In this case, I appear for respond number 1. The matter relates to a dispute as regards apportionment of the award passed by MSCT tribunal.
Yes.
The case.
Yes.
Now we had a talk. We want the matter to be resolved because it's the dispute between the mother-in-law and the daughter-in-law.
Okay.
So let this matter be referred to mediation.
Yes, madam. I have no objection, madam.
Heard Mr.
I'm Islam.
Learned counsel for the and Mr. A. Bhattacharya, learned counsel for the respondents.
I am for the respondent note to inches of.
And Mr. So and so. You are state counsel.
No,
Respond number 1.
Okay.
One of the claimants.
Okay. Respondent number 1.
1.
And
I'm 2 inches of.
for respondent number 2. Next one. It is submitted at the bar that the matter pertains to apportionment of the compensation amount in terms of as per the in terms of the award passed by the apportionment of the compensation amount. Of the award passed by the Motor Accident Claims Tribunal, Kamrup, within bracket M, bracket close, Guwahati. And the petitioner and the respondents are mother-in-law and daughter-in-law.
Yes.
Mother-in-law, daughter-in-law, who wish to get the matter referred to the mediation. No. The list of the petitioner and the respondent number
1
are the mother-in-law and the daughter-in-law who are desirous of getting the matter referred to the mediation. In view of above, let this matter be referred to mediation.
Yes.
Any mediator or
High Court mediation.
We'll simply say mediation. You don't have to appoint mediator at all.
Not required.
In view of above, as agreed to be learned counsel for the parties, as agreed to by the parties, let this matter be referred to High Court mediation.
Like.
Date may be fixed, my lord. Or within, my lord, 2 weeks, my lord.
Registry, then we'll say registry to place the matter before the mediation.
Yes. Right.
And the matter be listed after 3 weeks.
My lord. Early of last year.
Yes.
My lordship, in this writ petition, I have assailed an impugn order which is on page 14, my lordship.
May I say, Lordship, the private respondent, he has informed me, he has got pressure stroke. He has requested him also. He has, blood is coming, he is seeking adjournment.
Suddenly.
He has informed him also.
Morning.
When? Then?
Yesterday, Lord.
No, when it's to be listed in that case.
In short date, because it is.
Yes,
pending for-
he has
for-
not consented in the morning. Actually, it is a medical issue.
No, it's okay, we'll let you.
If it is a medical issue, my lordship,
Yes.
Heard Mr. So-and-so, learned counsel for the petitioner. Have you done this? This is the SPT, this are in vernacular, therefore.
yeah, 66.
Have you
my lord,
translated?
Page 66, my lordship.
Translated?
Yes, my lordship. Yes,
And translated and filed?
Yes, my lord.
You have filed also?
Yes, my lord.
We'll say, Mr.
Page-
Heard Mr. So-and-so, learned counsel for the petition, and Mr.
Ishan.
Peter Malan, standing counsel, AFDC. List of it is submitted by the learned counsel to the parties that as directed by this court, parties have translated the SBD and have already filed, have already brought on record list of next para. However, it is submitted by Mr. P. Sharma that Mr. Tapadar, learned counsel for the private respondent, has some medical issue, therefore has requested both the learned counsel for the petitioner and has informed the learned counsel for the petitioner and learned counsel for the petitioner and press for listing of the matter after 2 weeks. 2 weeks. Considering that the learned counsel for the petition, the respondent, private respondent, Mr. Tapadar, has some personal, has some medical issue. Come on, let this matter be listed after 2 weeks as prayed for.
If possible, my lordship. Possible.
2 weeks.
2 weeks, it will come, lord. Highly appreciate.
34 to 36.
Lordship, in the main case, there are 3 tender writ petitions of similar issue. They are being clubbed and placed together. And I am filing this application because on going through the different clauses of tender as well as RTI information, it is very much established that there are pre-bid criminal conspiracy activated by some senior official of the irrigation department who allotted the work worth rupees 6,440 lakh to a single bidder on single tender. So moreover, there is a provision of Article 299 Constitution of India. Lordship, may kindly be pleased to read page 11.
What about writ appeal? Order of this the division bench. It was related to some other matter, related to some other tender. Different tender.
Different tender.
2 different tenders.
But it's almost the same thing.
Similar, lord.
You are raising the same issue again and again.
No, this is
I know, maybe, I understand maybe different tender and different works. But then the complaint and the allegation are more or less same.
No, it's not similar.
By and large, is similar.
Not similar. Because I filed a...
What about this order of the writ appeal? In writ appeal?
No, I'm not agreed. There is no writ appeal.
This has been disposed of. Do you have that?
Yes, lord.
Writ appeal 434 of 2023.
My friend
This is different case. This case is...
I know different case, but you one after another you are filing all the tenders. How can this be allowed?
434 is different case. This is different case.
Lordship.
It's all right. Just wait.
Yes, both are different case. Both are there. 434 is...
I know. This writ appeal 434.
That has gone to even up to gone to Supreme Court. The Supreme Court said,
yes,
matter has gone to Supreme Court. I appeal Supreme Court.
Then
Supreme Court said that since this is a tender matter, this thing, that is okay, fine. But so far this matter is concerned, which I am now.
It's almost same thing.
No. This matter has been continuing last 17 months. This is not a today. This matter was initially listed on 4th of August 2023.
That's why we understand that.
Lordship, my submission is, this application is bringing the allegation with criminal conspiracy.
You file a complaint, criminal complaint.
You can file a FIR also, Lord.
You can file FIR, you can file complaint, you can file, you will go to Lok Ayukta, you can go to anywhere. There's so many forums.
No, Lordship, when matter has been pending before this honorable court, so how?
You close it,
Yes,
you will leave the liberty to approach the appropriate forum.
Yes. In fact, Lordship.
Sir, for a moment, we're not saying that what they are doing is wrong or right. We're not saying so. Because the manner you are filing the approaching this court, despite all this is, I know this is it's a separate or distinct work, tender. But the allegations are almost the same.
No, allegations not same, Lordship. It kindly go
Except the conspiracy angle and expect the allegation of single bidder. And accept the allegation of criminality, criminal conspiracy, whatever. You file an FIR, you approach the Lok Ayukta.
Then Lordship, can you pass an order?
Huh?
Then Lordship, can you please pass an order? File an FIR before the court. I'll be happy.
No, we'll not say, we'll give you a liberty. Better to withdraw.
No.
If I passed on merit, I may not grant you also. Of course, the liberty is always there. We cannot stop you from availing the remedy.
May kindly be pleased to go to this IA.
I have gone through.
And Lordship may pass an order giving me liberty to go to the local court. Because matter is pending, main case is not to dispose.
In any case, sir, who are you?
No.
What are your interests?
No, because I'm the contractor.
Are you a contractor?
Yes, Lordship.
We pursue as a diligent businessman.
No, this is then you, Lordship, unless and until you pass an order, I cannot do the matter. Either you can dismiss it on merit, that departing, but I cannot withdraw the order.
No, what I'm trying to impress upon you, rather than you impress upon the court, I find it, to be honest and to be frank, I find it is an unnecessary litigation.
Lordship, in my humble...
You are a businessman. Pursue your profession diligently.
Yeah. Lordship, but it does not mean that I will allow the authority to go for criminal conspiracy.
That's what I'm saying. If there's allegation, file an FIR. You complain to the appropriate authority.
But this matter is pending before this court already.
That's why we'll allow you to withdraw, to approach avail the remedy.
So you pass, Lordship, can you please pass an order?
No, if you agree to that, you will withdraw the writ petition with the liberty to approach avail the appropriate remedy. Available remedy, then we'll. Why not compel you to withdraw?
Lordship,
I'm just suggesting.
Lordship, I'll be
considering you being a businessman, a prudent businessman.
Lordship, I beg to submit. I am not going to withdraw it. If Lordship is pleased to dismiss the matter, dismiss it.
Then you argue. You argue.
This is on locus, Lordship.
But I don't find any ground of dismissal over here.
No, it's not a question of you argue. I have not heard you. You argue the matter. And another problem, they are raising your locus.
Lordship, then let them.
No, your registration is only valid up to 31st March 2025, right? You said contractor. No, we cannot deny you. You may be a contractor without registration also. But then technically and legally, unless your registration is valid, you cannot be considered to be a
I have not got
contractor.
the document. Let them file an affidavit and submit that. Give the reply.
Lordship, I can give him, Lordship. I can
This is not a way of getting. I get an order. Then
because Lordship, it is his document, Lordship.
I will file an
Sir,
affidavit.
Lordship, I will not place.
Sir, do you have
Lordship, I will be happy that let them file an affidavit with these findings, and I will give the reply, and finally it will be decided. If nothing, it will be decided.
apart from being a contractor, do you have the law degree?
No, I have not gone through.
You have not.
No, I never gone through.
Just want to linger the case, Lordship.
And in that case, you will appoint amicus. If you want to argue, you argue the matter.
Lordship, my humble submission, when I file this IA, I am fully satisfied there is enough merit because there is criminal conspiracy by the tendering authority. Prefix the tender on one single tender.
When there is a criminal conspiracy, what is which law regulates it?
No, I can go to look at no problem. But problem is matter has been pending this court for last 17 months. That is the issue.
Have you seen every day we're dealing with a matter which is pending since 2014, 2010?
That is
And it's a tender matter. It's not up to us. It's will go by the law.
Your pleasure, Lordship.
It's not our whims.
Lordship, pass order what you feel.
We are here for you, not only for all the litigants, for public. We are not for ourselves here. We are not here for ourselves. Try to understand, sir.
I got your point, Lordship, but then my submission is.
We are fixing it next week. Please reflect yourself.
After 15 days.
Not 15 days. Next week. Next week, huh?
The main case with petition has become infractions. The contractor who was allotted the work loss, if he has completed the work loss.
No, completion doesn't mean that the matter has become infractions. We may be difficult in granting a relief. It doesn't mean, sir. Let him reflect. I mean, I don't want to make any comment further. It's for your betterment. Next week we're listing for disposal. If you want to argue the matter, we'll hear you.
Yes, I will argue.
But then we don't encourage such type of you. Come up with a better grievance. All right. Not this kind of litigation, which I personally, judge would never encourage. If you have a genuine grievance, well, definitely. This is something, you read this judgment also, law has been laid down, relying on the Supreme Court judgment, how you are entitled, how you can approach the court as a contractor, as a bidder, right?
But my Lord, the humble submission, when there is a complaint makes certain offense.
Yes.
We cannot, when any complaint makes certain.
Have you filed any FIR?
No, because I am not filing the FIR because.
You file it if you are sure that if you think that these are the allegations, these are the criminal conspiracy, these are the criminal activities being done by the authorities.
Lordship, next week will.
Monday.
Wednesday.
You are from Guwahati.
Wednesday.
Guwahati.
Wednesday. Guwahati.
I'm repeating. Be a prudent businessman rather than indulge in such an unnecessary litigation. I'm sure you'll reflect on yourself within 1 week. Wednesday.
With 3rd of September.
As on the prayer of Mr. P.K. Bhattacharjee, Paresh Kumar Bhattacharjee, petitioner in person, let these matters be listed on 03/09/2025.
For final disposal.
On which date? Please stop, huh? Having on consideration of the nature of the grievance raised in these writ petitions. In these proceedings, it would be advisable for the petitioner in person to reflect on the grievances which he has sought to be raised, which he has raised as he, in view of the fact that there may be alternative efficacious remedy available under the law, as well as he being the prudent businessman. List accordingly. Mr. So-and-so is.
37.
My lord.
Yes.
Malad, in terms of last court's order, Malad,
Ah,
the meeting has been held, Malad,
ah.
and they're supposed to issue a corrigendum, Malad, to that effect, Malad, regarding point number 5. So matter will be resolved, but we need some time, Malad. They will be after Malad vacation because they are enjoying stay, Malad. They are not, Malad.
It's not a question of enjoying. Court has passed an interim order, so.
My prayer is that he should not suffer for my taking time, Malad. So
Okay.
maybe
Every day we have suffering, my lord.
Yeah.
We have a 136 holding
Malad,
in the town. Let me submit. The 136 holding, my lord. Now the municipal board, due to this litigation, they have stopped the issuance of the permission, etc., etc. So we are intending to dispose the matter as early as possible.
No,
Now-
once they issued a corrigendum. I
They have
think
already
that
held
will-
a
that
meeting,
will
my
be
lord.
re- that
They
will-
have take 3 months
It will
time.
take care of your grievance.
No.
We'll
Yes.
see, we'll see.
Lordship,
Since
If they
it has
assured,
been-
if they assured, my lord,
See,
that
this
before this honorable court, that they will also redress the issues raised by in the writ petition, we are agreeable.
on the other days, this court has taken cognizance and taken note of what is happening.
No, my lord.
Therefore, there is a record, it has been taken note of, and therefore.
Yes, if that being so, we have nothing,
Ah.
no problem.
maybe
Our-
instead after
Our
vacation.
vacation?
After the vacation,
What is vacation?
Malad,
When is the vacation?
vacation.
It's too far.
October, in the month of
So
October.
next week of September, my lord.
Once you have taken a decision, what's the
Required time because the corrigendum has to become lordship, then we have to resolve this issue. We are the
Yes.
municipal authority.
Yes, Malad, because
That's why.
only meeting has been held and they have decided.
Then my lord may kindly indicate that our renewal and permission, whichever being pending, that may be considered by the municipal
That
board.
was not his
His
prayer, lordship.
prayer.
His prayer as well.
So I will not go into all these things. Since,
So then the matter may be
since
discussed.
you have, as I said, this court has taken note of what is going on.
My lord.
On the presence of this has been, there's a recording. So let us wait for some time. I understand you must be,
That's, I have nothing to say, my lord.
Okay.
Let them take a time,
you
but
decide the time, that's all.
Now,
they.
Had Mr.
Either.
Be the learned senior counsel assisted by Mr. So-and-so, learned counsel for the petitioner. It is submitted by Mr. S.S. Roy, learned distinct counsel for Tinsukia Municipal Board, and M.S.
you does, Malad.
You does for additional senior government advocate. That the meeting as proposed to be held has been already convened on when?
21/8.
21/8/2025. List of the what decision you have taken?
There was some clarification sought by the municipal board regarding the notification dated
10/3/2020.
It is no, in view of the decision taken in the meeting, it is expected that the petitioner, the grievance of the petitioner, grievance raised by the petitioner may be redressed. Please, how
By publishing a corrigendum.
no, how about
by way of corrigendum.
for implementation of the decision, a corrigendum would be issued, which may take some time. Therefore, phrase that matter may be listed after a.
The
After
15th or 16th, my lord, may the date be fixed, my lord. I'm traveling outside. So 15th
After-
or
15 October, Malad.
15th October.
October.
15th October.
Let it be on 23rd.
After
Okay.
four,
I'm not, you understand, Mr. Roy.
After-
No, the court will be open on 15th October.
after 4 weeks, please stuff. As agreed to by,
Let the date may
as
be-
agreed to by the learned counsel for the learned senior counsel and as well to the parties let this matter be listed on 16th of October, 16/10/2025.
My lord. The interim order may be continued.
Interim order was earlier shall continue.
My lord. Yeah.
Please, your lordship.
Yes,
The respondents has filed affidavit in opposition.
yes.
So we'll the rejoinder very.
What is the matter? What is the matter? Anyway,
It's
on the prayer of MS so-and-so learned counsel for the petitioner. Further, 3 weeks' time is granted to file affidavit in reply. Mr. So-and-so learned counsel for the respondents is present. Yes, enterprise.
May I please, my lord.
Yes.
The writ petitioner's prayer to shift his IMFL off shop from one location to another was rejected by the impugned order.
So,
I am against that. My lord finds the impugned order at page number 48 of the writ petition.
48.
48, my lord. No, the ground taken herein, the major ground taken hearing is that the shop, which is the proposed site, is within the distance of 100 meters from the midpoint of the national highway.
yes. What's wrong?
My lord, what I'm trying to impress upon this court is that if my lord comes to page number 30, which is the checklist, model form of checklist provided prior.
It's okay. It's okay. Then this is within around 23 meters from the midpoint of national highway.
That is the case, my lord.
And there is a the Tumuki Medical College and hospital is also there.
My lord, they are at distances 900 meters and 460 meters. Here we have complied the mandate of Rule 289.
And what is the judgment of the Honorable Supreme Court?
Sir?
What is the judgment of the Honorable Supreme
My
Court?
lord, in the Arrive Safe Society, it was stated that in the case of Arrive Safe Society, it was stated, my lord, I'll just quote it. I have the judgment.
So this why you want to shift?
My lord, we were in under tenanted premises.
Huh?
We were running the IMFL off shop. The writ petitioner was running it from a tenanted premises in a different location. The landlord has served upon us a notice to vacate the premises, and on that ground we have made an application.
Yes.
During the process.
Is it in conformity with the excise rules?
Yes, my lord. As per Rule 294A.
Definitely, you will say so. What do you say?
This is the objection, your lordship. There are objections from the people residing in that area.
Yes.
Opposing the shifting, and as far as he's running his premises till now, your lordship. That he's running his premises. He's running his shop.
No, it's not that. Whether the proposed area is he maintaining the distance? Distances are maintained.
The distance, your lordship, there's an
In terms
inquiry.
of the rules.
Inquiry is there, your lordship. Inquiry report is there, your lordship. At page 56. Says that the physical verification as per clause 289(2), 260, proposed site is 405 meters away from Tezpur Medical College main gate. And 163 meters to the boundary wall around education institution, around 800 meters from the religious institution. Here, even now, the occupiers and residences residing near in that area, they have come with the objection.
Once it is objection, you cannot allow.
No, we cannot allow if the objection are found to be bona fide.
That is not the case, madam.
What is the inquiry report is where?
Inquiry report is at page 56, your lordship.
How do we read it? It's not legible.
There's that type copy is by page 55, your lordship. Reference certified above, you are not to submit here with the joint inquiry report regarding proposal shifting IMFL on retail shop by Yash Enterprise to Tumuki, Pinduguri. The proposed site is located at Kerwagaon under Bihagori Moza, bearing PP number so and so, Patada, Jilbin Soikeo. After physical verification is found as per clause 28.9 to the Assam Excise Rule 16, the proposed site is 105 meters approx away from the Tezpur Medical College main gate and around 800 meters away from religious institution. However, the proposed site of retail of liquor situated within 100 meters of Midpur National Highway 15, around 20 meters approx. Further, Tumuki Gaon Panchayat issued an urban nature certificate area. So dated so and so. However, Tumuki Bihaguri is not under the jurisdiction of government notified urban local body area, and as per revenue culture, rural area. The moment it comes to the rural area, your lordship, that this distance criteria from the highway comes to play.
As per section clause 289(2).
289(2).
Well, here my argument is that there is an urban in nature certificate. Though they say so, if my lord may kindly peruse page 81 of my rejoinder to their affidavit in reply.
81.
81, my lord.
No, there's a clear finding. Are you challenging this report?
No.
Are you challenging this report? The rejection is based clearly on the basis.
My lord, I'm challenging
based on the inquiry report.
I'm challenging the inquiry. I'm challenging the order of rejection, my lord.
That is based on the inquiry report.
My lord, the case is that in that area.
I have understood. You don't want to be there. You cannot run. You are not. You are unable to run your liquor shop where you present in the present location as it is under the you are a tenant there.
Yes, my lord.
Your landlord wants you to vacate.
Yes, my lord.
So you want to shift.
I want to
now problem is the proposed area is as per the rules. It can be permitted or not, that is to be seen. So as per the inquiry report, it's within 23 meters of the national highway.
My lord, that is what I'm trying to impress.
And nearby there are medical college, maybe 800 meters away. And the area doesn't fall under the urban, it's a rural area. There's a complaint by the public, opposition is there. So matter ends there.
My lord, as per the medical and education institutions, I qualify for the norms under sub-rule 2 of 289. Rule 289. That part, that argument cannot be held on against the petition.
Because it has to be, it should not be within 100 meters.
Yeah, 100 and 150 meters. I am beyond that.
Yes.
That part is covered.
Then what have the complaint of the opposition by the locality, people of that locality?
Malo, the complaint was made before the authority. While passing the order of rejection, those must have been taken into consideration.
Yes.
Malo, but the major ground which they are posing is the distance from the national highway. And in that very locality, another wine shop is being run, which is also within the distance of 100 meters.
No, that may be wrong.
That may be wrong, my lord. What I am on is the arbitrariness of the decision. Therefore, I am asking your lordship's kind and only to page number 82 of my rejoinder.
82.
82, my lord. My lord, may kindly start with 81. I'll just point out 2 paragraphs here.
Inquiry report.
Inquiry report, ma'am.
Yes, 81.
81, my lord. At the last paragraph, point number 3, however. However, Government of Assam issued an order number such and such dated 5th of March 2018, in which it is stated that whereas in view of the above, Government of Assam in the Excise Department has decided to grant exemption to areas, whether notified or unnotified, my lord, the notification does not matter, which are urban in nature or an area in transition from a rural area to an urban area. Accordingly, the representations so far received along with the supporting documents are duly perused and considered, and the following license are found to be entitled for exemption from the restrictive distance criteria provided by the Honorable Supreme Court. Though these orders were specific to a certain number of licenses, same principle may be adopted if the competent authority decides to allow the petition under consideration with explicit order of the government in this regard.
This is by whom?
This is by the Inspector of Excise, Sonitpur, Tezpur.
Why another inquiry? This is based on
Prior
what?
to preferring the writ petition, the writ petitioner had made a representation before the authorities. And since no action was taken, the writ petition was filed, but during the pendency of the writ petition, this report was submitted by the Inspector of Excise, which we have brought on record by means of the rejoinder. On the next page, my lord, at point number 8, if I may read, it may also be mentioned here. May I read, my lord? Mentioned here that in the same location of the proposed site at a distance of 80 meters, there is another licensed IMFL lawn shop, namely Messrs. Coing Bar and Restaurant, operating peacefully, which was also issued license on the basis of urban in nature certificate issued by the Tumuki Gaon Panchayat. This is the very certificate which was issued to us as well. The licensed IMFL lawn shop is in operation in the located distance is located in a distance of 50 meters from the midpoint of National Highway, that is less than 100 meters, madam. My lord, what I am on is there cannot be arbitrariness in decision of the government. The state has to be fair and reasonable in its decision. On one hand, considering the very urban in nature certificate for one candidate and not for one licensee and not considering the same in case of the writ petitioner would amount to arbitrariness and unfair play, my lord, here. In respect to the objection also, it is mentioned, my lord, on the subsequent points. That the NOC from the residents of the nearby 75 meters was also provided. 75 meters is the distance which has been provided in the rules framed under the Excise Act.
Yes, maybe because of that you want some time to go through this.
We have gone through this, and he says that he have taken NOC from the person residing 75 meters. But where is the NOC, your lordship? Where is the NOC of an
See,
my lord, there is a report.
as the affidavit has been filed today only and copy there has been furnished to you, he would like to go through this. Yes. So this is by your officer only, Inspector of Excise.
Yes. But they say that the applicant also submitted an NOC from the residents within the perimeter of 75 meters from the proposed site. They are admitting to it.
Where the
Page number 82.
This is submitted to whom?
To the district commissioner, my lord.
Okay, we being the residents of complain before the authorities, saying that we are resident within 75-meter radius, and our complaint has not been considered by the.
No, at present they are not a parties to the writ petition. At present they are not parties.
They have filed an IA for improvement, therefore.
You have filed.
Yes. And they have filed taking that we could not place anything on record, saying that we are residents of 75 meters.
Bhargav Jyotinath.
Yes.
It has not been disposed of.
No, my lord.
No.
So what is to be done?
My lord, even in that case, in the interlocutory application, if I am to make my submissions, they say that they are residents within the same. At page 10 of their interlocutory application, at the portions where they put their signature, they mention their address at Dag number 666 of Patta number 350. In the writ petitioner's affidavit in opposition, we have annexed the Jomabandi of that particular Dag, which shows that the Pattadar of that Dag is Dibas Subedi. And along with the same, in our reply, we have also annexed the no objection certificate of Dibas Subedi, who is the owner of that plot, who is the Pattadar. Malad, these are all unscrupulous and
Dibas Subedi lordship, as per my instruction, he stays in Dekia, which is far more.
Nothing has been stated on record as of now.
Because we are yet to be implemented, therefore we did not.
This was the stand in the interlocutory application, but what they are now submitting is that Mr. Divas Subedi, who is the
Now, what have you done on the report?
Lordship,
Nothing has been done on that.
We are residing in a plot which is owned by Divas Subedi. We are the occupants under Divas Subedi. So we have filed an NOC for objection.
Might be, my lord, but Divas Subedi, once the pattadar of the land has given an objection, for them to come and say undoubtedly raises a suspicious circumstance in that regard.
Since we are residing in that particular.
Coupled with the fact.
No, admittedly, they are residing.
Yes.
My lord.
They are residing within the locality.
My lord,
in the proposed area.
That we have questioned that they have not provided any document to show that they are residing within the.
Number 9, we have clearly stated in our thing before the authorities that.
Who has caused this inquiry? Latest inquiry, page 82, 81.
Inspector of Excise, Your Lordship.
Who has caused it? The the district commissioner.
But the report is addressed to the district commissioner.
And rejection is by whom? District commissioner.
District commissioner, sorry for my lord.
Huh?
District commissioner.
So that's why who has caused this inquiry after rejection? Rejection is page, impute rejection.
Rejection, my lord, page 48.
48. Zero 29. Then this is 25.9.
If your lordship is the rejection order, which is under challenge.
Inspectors to ensure inquiry for re-examiner shifting proposal. I must just enter difference. I have the honor to conclude the inquiry for re-examiner shifting proposal from It is Inspector of Excise has done his own inquiry or sumoto inquiry or by
There are two letters, Your Lordship. If you may kindly see the report from the inspector, page 69. The reference of 2 letters, Your Lordship.
My lord, we had prepared a representation which is at page 76.
Before Deputy Commissioner,
no,
District Commissioner.
We had addressed it to the Chief Minister Assam and Honorable Excise Minister. And a copy was also addressed to the Commissioner and Secretary Government.
Then you go to them.
My lord.
You go to them, to the honorables.
No, my lord, this was prior to approaching this court, my lord.
Go to them now also.
My lord, I am not on that point, my lord. What I am on is that the arbitrariness which was shown here, my lord.
See, arbitrariness it's a big ocean. Don't simply say arbitrary.
My lord, I am showing it from the inquiry report which says that on one hand, on the same ground, somebody was granted. It may be right or it may not. It may be wrong. My lord, when on a particular procedure, on grant of a particular certificate,
maybe that was not legal.
That was the procedure cannot change for the writ petitioner.
No, it's not a question of changing. See, requirement is that they should not have the certain the distance has to be maintained. And it should not be
Objection has to be taken care of.
Objection of the
local
public has to be taken into consideration.
Objections, my lord, has to be taken into consideration as per Rule 289. And
the rejection order even complaints said that several complaints have been received, Your Lordship.
But problem is how you have caused an inquiry again.
This affidavit they have filed, I might have taken instruction on what basis this inquiry has been caused, Your Lordship. Because this affidavit they have filed and they have annexed this.
They may take instructions from the figure.
You take instruction.
Very well, Lordship.
In that case, Lordship, reading.
Simple is the method is very simple. Certain grounds you have rejected. Again, you have caused an inquiry.
Yes, Your Lordship. On what basis the inquiry was again conducted? That has to be taken.
And the inquiry is in his favor.
Inquiry in his favor, but the earlier inquiry was against his second inquiry was again in his favor.
No, first inquiry on the basis of first inquiry by the circle officer you have rejected. Now after nearly a year.
Rejection, a second inquiry conducted. accepting
after
it.
6 months, you have again posed an inquiry which is pending before you. You take an
Very
instruction
well, I'll take this on what basis is inquiry conduct.
next week, after 2 weeks.
After 2 weeks, also.
Or Mr. Will allow him to implement, will allow.
My lord may record my objection.
What objection?
My lord, he has not supported his application with any document to show that
He
he
is the
resides
local residence of that
within
local.
75 meters as per the established.
That in the complaint itself, it is specifically mentioned, a snapshot of Google snapshot has been annexed, which is with the department. A snapshot of that particular area is annexed with the complaint.
Not a snapshot, you show us. Are you a resident?
Yes.
Really?
In fact, I'm a tenant of the Vikas Subedi, which my learned friend on.
Heard Mr. So-and-so learned counsel for the petitioner. And also so-and-so, R.R. Gogoi for respondent, standing counsel.
Excise Department.
Excise Department, Government of Assam. Next.
1, 2, 3, and 5.
Having considered that after the impugn rejection, that is 0902.
0209. 0209 2024.
24, 0209,
Yes, ma'am.
2024. By the District Commissioner, Sonitpur District, whereby a shifting of IMFL on soft from
Offshore.
where? Huh?
Offshore, my lord.
Off.
Off.
IMF offshore from where?
From my lord Misamari to Geruagao, Bihaguri.
From Misamari to Gereagao,
Bihaguri.
Misamari to
Erua Gaon, Bihoguri.
Gereagao, Tumki. Huh?
Yes, my lord. Yes, my lord. Tumuki Gaon Panchayat.
Tumuki, Gaon Panchayat. Has been rejected. What I said. Oh, IMFL offshore. Has been rejected. Another inquiry by the inquiry dated 25/05/2025 by the Inspector Excise, Sonitpur District, appears to have been caused and submitted whereby it is with the findings in favor of the petitioner, Mr. Government and State understood to obtain instruction. Listed matter after 2 weeks, huh? No, we'll say, we'll allow this IA in IA. Not Mr. So-and-so, learned counsel for the petitioner, applicant, and Mr. for Chaudhary for opposite party of the lead petitioner and Mr. R.R. Gowri. This is an application for implement of the, this is the application for seeking implement of the petitioner, applicant. Only one. Applicants, huh? Applicants in the connected WPC 513 of 2024 as respondent number
6 and 7.
6 and 7.
6 and 7. 6 and 7.
It is the contention of the counsel for the applicants that the petition applicants are the residents of the locality of what Gerua under Tumki Panchayat, wherein the petitioner has proposed to shift his IMFL offshore from Misamari. List of the applicants have made an objection in view of the fact that the setting up of IMFL, setting up shifting of IMFL soft by the petitioner would adversely affect the people of the area, and the proposed area is located not within the permissible limit, permissible distance under the provisions of what?
Assam Excise Act
Assam
2000
Excise Act
and Assam Excise Rules 2016.
and rules 2016. Assam Excise
Excise
Act 2000
and rules
and the
2000.
rules framed thereunder. List of Mr. So-and-so, learned counsel for the opposite for the writ petition vehemently objected to the prayer for impleadment on the ground that the petitioners have not shown that they are the permanent resident of the area where the IMFL shop of the petitioner is sought to be shifted. List of the area shown to have been the area where the applicants claims to be residing is belongs to one what?
Divorce Subedi, my lord.
Divorce?
Subedi.
Divorce.
DIBAS.
Divorce. DIBS. Divorce Subedi.
Subedi. SUBEDI.
Subedi. List of therefore the petitioner has the applicants are not the necessary party. Expert. On having considered the submissions of the learned counsel by the parties and also and on perusal of the materials, it appears that the petition applicants are the residents of the locality where the petitioner has proposed to shift his IMFL offshore, which may have an adverse effect to the people of the area, including the applicants, I'm of the considered view that the applicants are the necessary parties in the present proceedings. List of accordingly, the applicants are allowed to be included as party respondent number 6 and 7 in the above connected with WPC so and so. The writ petition, the interlegal application stands allowed in disposal. In writ petition, again you write, in view of the order passed in IS so and so. That will be in the first, and then you write the earlier, orders. Next, so and so you the petitioners to file an co-settle, amended co-settle, list of the registry to incorporate the name of the newly included respondent of 6 and 7. List of, then you write the next first order. That's all.
Correction we made to show my name in the court list.
Obviously, once you have signed the Wakalat Nama.
Yes.
Obliged. Deeply obliged.
Maybe the loss of interest process, I have received the Paras covenant. We get the affidavit and sign it. Can I be after 2 weeks in this?
Last occasion 3 weeks. Now 2 weeks.
Already I signed it for vetting.
Lordship, kindly fix a date, Lordship.
Why? What is the matter?
Matter is regarding non-payment of contextual dues, Lordship.
It's okay.
Lordship, Lordship, they had to make.
Heard Mr. So-and-so learned counsel for the petitioner. On the prayer of Mr. N.J. Gogoi, Learned State Council, huh?
Any council,
Standing Council for of what?
Assam
Agri-
State Agriculture Marketing Board.
Huh?
Assam State Agriculture Marketing Board.
Assam State Agriculture Marketing Board. Further 3 weeks time is granted to file affidavit in opposition.
The scheme is under the EPIDA, so EPIDA is a necessary party.
Lordship, I may be allowed, I will pay, Lordship.
Scheme is under the EPIDA, we are the only implementing agency.
The
I'm for respondent 1 and 2.
so and so. You are not filing affidavit. So and so is present for respondent number 1 and 2. It is stated at the bar that the what is the APEDA?
That means Lordship.
Assam?
Agriculture and Processed Food Products Development Authority.
Assam Agriculture.
Agriculture and Processed Food Products Agency is a necessary party, Lordship, because work, the scheme is under the EPIDA, Lordship.
Sir, tell us what is APEDA.
I am saying the EPIDA, Lordship, selling the EPIDA.
Agriculture?
Agriculture and Processed Food Products Development Authority.
Find at page 20.
It is submitted by the Learned Council for the parties that the agriculture
and
process
food products development
authority, comma Assam
no, so it is a national
authority. You just write it. Give it. Is it this in proceedings? However, the petitioner has not added them as a party respondents. List of in view of Mr. So-and-so Learned Council petitioner seeks time to file appropriate application for amendment. List of prayers allowed. List the matter after 3 weeks.
Fix a date, Lordship.
3 weeks. First file an application.
This is also, Lordship, they are the respondent, Lordship, and in that
received by Senate for vetting.
Same order, heard Mr. So-and-so Learned Council for the petition.
In this case, Lordship, necessary party.
Further 3 weeks time is granted to NG so-and-so, huh?
In this case, the necessary party is NABARD, Lordship.
NABARD, huh? Same order, NABARD.
NABARD is a necessary
National what? National?
NABARD is National Bank for Agriculture and Rural Development.
NABARD, the final. Same order.
obliged, Lordship.
Contractual amount, my lord, the claims are of 1998, my lord, to 2006. Whole issue, my lord, little after 3 weeks, my lord.
My lord, this is, my lord, appreciated with the representation, my lord.
Huh?
Later, we have filed representation again and again, but that was not solved. So notice was issued.
Only 1997. Filing representation after representation. That should not.
Due to my lord,
Heard Mr. So-and-so Learned Council for the petitioner. Dismiss, read petition, dismiss.
my lord,
In view of the judgment of this court so-and-so.
my notice was issued earlier, my lord.
You what?
My lord,
That's why we're dismissing a writ petition. His claim is of 2090, what? 2000?
1998.
1998 up to
he
2006.
did not pay, for which my lord I have filed.
What is the Gogoi, what is the judgment of this court?
I will provide them. In fact, my lord, division bench also affirmed it, my lord.
We'll fix up after a week for dismissal. You also go through it. I'm giving you a chance after 2 weeks.
My lord.
Huh? Heard Mr. So-and-so Learned Council for the petitioner. And Mr. B. Gogoi, Learned Additional Advocacy for the State of Assam. List of the claim of the petitioner for payment of for a direction for payment of an outstanding bill amount is for the period 1998 to 2006, which prima facie for which prima facie the writ petition may not be maintainable. I'm saying prima facie list of may not be maintainable, huh?
My lord, simply for adjournment, my lord, after 2 years. Simply for adjournment, since they are.
That's okay. Of 1998 to 2006, comma, the for for further consideration and as spread for learned counsel for the party petitioner, let this matter be listed after 2 weeks. 2 weeks. You work out. Find out. Have some serious research on it.
Yes.
Same.
Same.
Same order. What is 44? Over. Huh? No, 44. 44 billing is over. 44 over. Okay.
45.
Yes.
According to respondent number by the respondent number 4. I need 2 weeks time to file our objection. I have read instructions, but the documents are in vernacular medium, so
What is the matter, sir?
Matter is because settlement of a fishery by
Okay.
the Assam Fishery Development Corporation. The impugn order starts at page 67, whereby my lord, I was removed and they were placed in the position.
Anyway.
It was in pursuance to a writ appeals order where there was direction for hearing. So hearing was done. This impugn order comes in. You have challenged this
Against you. Against you.
Yes.
Who has filed the writ petition?
But I have the
At the instance of the whom the order in the writ appeal was passed.
the private respondent.
Okay. So anyway,
Here I have a lordship, kindly go to the order dated lordship.
You are for?
I'm AFDC lordship.
They may reflect the order dated
6/5/2025.
But that was only to instruction to implement the previous.
6/5/2025.
This is not only instruction, but we will not
Well,
implement.
that instruction should be completed, that order. Because lordship, the crux of the case is this.
My lord, it is my lord, the plaint starts with the right to pleading is with the plaintiff. That is the petitioner. Respondent cannot say what is the cause of action and who are the necessary party. If I fail, that I will fail through my pleadings.
So you don't want to?
I don't want.
Okay.
Respondent cannot come and argue that they are necessary party.
Another matter, lordship.
Well, look, today we'll grant some time.
No, lordship, in minimum thing, lordship, page number 33, lordship. There is a vernacular translation from the vernacular part, lordship. The dispute, lordship, may I pay lordship one thing, lordship, that vernacular part, the clause is very much important. The crux of the case revolves and the clause part.
That's why she's seeking time. They'll translate and file. Heard Mr. Fikir Chaudhary.
The translation department also to
Learned,
because there is a dispute, they have translated in
learned counsel for the petitioner on the prayer of Mr. P. Sharma, standing counsel. AFDC and Miss MS for State Council and council for respond number 8, 4, 6, and 7. List this matter after 3 weeks. So
Not
it's to
3 weeks. They are sick for 2 weeks.
2 weeks.
They are enjoying with
2 weeks. So it's 2 weeks. For filing affidavit, it is submit as please look, since the clauses since the SBD is in vernacular, NIT and the SBD is in vernacular,
and clauses are in
SBD, no, NIT and the SBD is in vernacular. The learned counsel to the respondents to translate and file to place on record.
Date be fixed, man.
After 2 weeks.
Man, any date, man.
After 2 weeks,
We'll see. 2 weeks.
Because, I am suffering,
Who is running the?
They are running, respondent of private.
they have settled it through tender process, not it?
And then there was a dispute, there was a hearing, then there was again.
After 2 weeks, you just give the date.
11th September.
After 15 September,
Yes, Mr. Roy. After 15 September. 17.
Vishwakarma Puja, give it some other day.
19. Yeah. Ah, 47.
Matter relates to non-payment of contractual bills.
Okay.
They are saying that, in fact, we have filed our GST return. Since the GST return was not filed, that's why amount was not disbursed, my lord. My lord, there is no connection with filing of GST return and, my lord, payment of my contractual bill. As per their affidavit, so that will be, my lord, it is a domain of GST department, my lord. Or whatever the amount I will receive, that amount on the whatever the GST that I will pay. But despite that, my lord, I have my returns are up to date, so matter may be disposed of. Your lordship may direct them to verify, and if I am entitled, my lord, within certain time limit, payment may be made.
Lordship, may I plead your lordship?
Yes.
Lordship, we have submitted his ceiling and bill to the Treasury, your lordship, in the month of February, your lordship. But Treasury rejected his claim because his GST is not up to date. When he filed additional affidavit, I verified it from the department, your lordship. They said that he has submitted GST up to January 2025. We have issued letter on 7th of August 2025, your lordship. That instruction today I have received, your lordship. Department has written to the petitioner that kindly up to date your GST, because of which Treasury has rejected, not us, your lordship. That is not our fault, your lordship. We have already submitted because Treasury did not allow.
To understand, my lord.
Since his GST is not up to date.
It is up to date.
Mr.
Page 45, it is up to date.
Page
45 of additional affidavit, my lord.
Additional affidavit?
Lordship, my prayer is let Lordship direct him to update his GST till the running month.
It's good for you only. Mr. Goel.
I will file, my lord.
May not be connected, but they are facing difficulty. Just because of that, it may not.
There is no difficulty, my lord.
They are facing difficulty. You want money or not?
My lord?
I want the money or not?
I want money, my lord.
Then?
That's why it is up to date.
It is very simple.
It is up to date, my lord. Page 45.
Page 45. Where it is?
Financial year, Lordship, it is for financial year 2023-24.
23-24, relating to work done during that period, my lord.
No.
Your lordship, our instruction is to
Goods and services 2020 site last update 24/1. Yes.
At the bottom, your lordship will see the amount 16,82,411. Against their bill, my lord, we have already filed. It is not that up to date is required.
No. Treasury is rejecting, sir. What is the amount?
At the bottom, my lord, total invoice value 16,82,411. This is my amount, my lord. That we have paid, my lord. Against that, we have paid central GST, state GST. So against that bill already.
How many amount? What is the total amount you are claiming?
16 lakh.
Your bill.
16,82,411. That is the amount, my lord.
Bill.
The 16 lakh 82,400. My bill on page 31. Same amount against same amount we have paid GST. Page 31 is my bill at 16,82,411. This is the exact amount, my lord.
No, she's expressing certain difficulty. It's not that they are no, you are not entitled. You will be paid. They say they submitted.
They can say that against the payment, whether I have made the GST payment or not. Against that payment, because when the invoice has been raised, I have to pay, file return, and I have to, without irrespective of the fact that that amount I have received
No,
or not.
are you not required to update your GST?
But that is governed by GST Act, and
It's all right. It's not.
But here you also will see page 45, same amount for 16,82,411. Against that, GST has been paid, central GST, state GST.
So why she has to make that submission?
That's why I fail to understand.
Treasury, your lordship, Treasury has rejected.
Already we have made the payment. Already we have made the payment, page 45.
The Treasury made.
So they can't retain my money, your lordship. Treasury, but it may be Treasury. I will make party. I don't know whether who has kept my.
That is my instruction. Without updating GST, it is not possible because filling it lapsed, your lordship. Treasury has rejected. We have submitted on February.
I think Treasury has not gone through this, whether it was payment was made or not. That's why they have done this.
Then you clarify from Treasury, your lordship.
Page 45. In view of page 45.
No. In that case, this is the hurdles is by the Treasury, right? In that case, either you make the Treasury party. What is called Treasury is?
Treasury, lordship.
What is Treasury? Accountant General or what? Huh?
Let them make party.
It's better because they are ready to pay.
Yes, your lord.
Hurdles are being
I will file my return as per calculation and all. I will take my time, but Treasury can't insist me to file my return.
No, problem is that how it is paid. It has to be clearance from the Treasury.
Yes.
The department is ready to pay you. It's a matter of whether you submit the up-to-date GST
tomorrow they will,
or you make them a party.
My lord, that's why I will make.
Otherwise, we cannot pass.
I will make them party
Without being a party.
Provide us the address and all. I will make party.
Treasury officer Jorhat, your lord.
Treasury officer Jorhat.
My lord.
Who is the boss of that? Finance.
Finance, your lord.
Then you have to make the finance is there.
Finance is there, your lord.
Finance is there, my lord. I have made party.
Treasury officer. Huh?
So that
Heard Mr. A. Goyal, learned counsel for the petitioner. It is submitted by MS Ardeka, learned counsel, Assistant Counsel, Water Resource Department.
Finance, my lord. Finance Department. Respondent number 3.
And you make them party Treasury. Treasury officer.
Under Finance Department.
Treasury officer, it will be too. Either you want to simplify it or expedite, or you want to.
My lord, I want to expedite. But
then you make them a party who is objecting, right? It will go and go, go round and round. Huh?
My lord.
So that although the department has submitted the bill amount to the Treasury.
Jorhat, your lord.
Jorhat, in view of non-submission of GST. What do we call final or the latest?
Yes, your lord. Up to date.
Up to date GST. The Treasury officer has created the hurdles and has not been able to clear for payment of the amount claimed by the petitioner.
My lord, may record my submission. It is not required.
Huh?
Treasury, that up to date.
No, you make them a party, that's all. All right.
My lord.
Oh, and then next paragraph. Mr. Goyal, learned counsel for the petitioner. In response to such submission, such submission of the MS Deka, the Listening Council, that the payment of GST has nothing to do with the up-to-date payment of GST is nothing to do with the claim of the petitioner.
Right.
As the petitioner has already paid the GST for financial year 2023 to 2024 body
Against the
invoice, huh? For the amount
16 lakh.
for the claim amount, huh? Mr. However, he fairly submits that since if the office, the treasury is creating hurdles, come on, you would add we will implement the officer, the treasury officer Jorhat in this present proceeding. Therefore, for which he prays for listing the matter after a week,
Right.
so that you can implement and you can issue notice. All right.
And the next matter, Marco, same.
Prayer for of the Amit.
The next is.
Prayer for so and so. Prayer. Let this matter be listed. And be above. Let this matter be listed after a week. In the meantime, Mr. Goyal may find appropriate application for implement. Huh?
This matter is also same, Mala, but we are here, Mala.
50?
55. On the last occasion, Mala, we placed our instruction in the last paragraph, first letter, Mala. The Lordship, because of Mala not updating their GST payment, Mala.
Same order. Same order.
Mala.
Name will be different.
Mala.
In place of Ardeka, MS.
Yuda.
Yuda.
Additional senior governor.
Additional senior.
Dispute treasury.
Dispute treasury, yes.
Officer. Treasury officer.
After only.
This dispute treasury, Mala. This case is dispute treasury.
No, officer, treasury officer dispute.
Dispute.
Will save to say.
Mala.
Oblige.
Next.
Yes.
The contempt for non-payment of the contractual bill.
Lordship, the operative portion is at page 15, Lordship, paragraph 8. Lordship, a direction was issued to take up an exercise to consider the entitlement of the petitioner, Lordship. If he is found entitled, then pay forfeit. Lordship, in terms of this order, Lordship, a list was prepared. And his name was listed at serial number 30. In the last financial year, Lordship, we have paid up to serial number 29. And in this financial year, we are going to release his dues, Lordship. And so far as instruction is concerned, today I have received, Lordship. For this purpose, Lordship, an amount has already been allotted to the concerned department, Lordship. So one week it will be difficult, Lordship. Lordship will take up this matter after 4 weeks, Lordship. In the meantime, he is at serial number 1 now, Lordship.
I'm waiting since 2022, my lord. Yeah.
4 weeks will be too much. Make it 3 weeks.
No, Lordship, my problem will be, Lordship.
You have already,
no,
the fund has been sanctioned already.
It has been allotted, Lord.
Allotted.
The court said it has been allotted.
Yes.
And he is at serial number 1. Whenever it starts, he will be the first person.
No, that's why you expedite it.
I'm trying, Lordship. I'm pursuing.
We'll make it after three weeks. Like 3 weeks. Taking the little lenient view. Heard Mr. So Counsel for the petition. In terms of the order dated 29/07/2025 passed by this court, Mr. P. Nayak, Land Counsel for the petition, submits that the amount entitled to be paid to the petition has already been allotted to the department.
Yes, concerned
department. Or
yes,
to the
PWD.
concerned department. Mr. However, to process for payment, it will take some time. Therefore, first for listing the matter after 3 weeks. It is expected that the respondent authorities will release the amount entitled to the petitioner on or before the next date of listing. Person expected. You expedite it. unnecessary.
Even my personal.
Otherwise, we're taking lenient view.
Lordship.
It's a contempt proceeding.
Lordship, I understand. Lordship. This is regarding the Water Resources Department. Whether the Water Resources Department, that amount has been allotted or not. That may be clarified.
Well, I've recorded. If it has not been allotted, we'll see on the next date. Have a faith on the additional advocate general.
Lordship, I'll place the status quo on the next.
Not a status quo. You pay it. We'll close the next date. We'll close the matter.
I'll pay Lordship.
Right.
Yes.
About 49, 50, 51, and 52 are matters pertaining to non-payment of contractual dues, my lord.
Yes.
4 matters were taken up on 6/8/2025, where a direction was given to the state authority.
Going on, and some more time would be required, and it says he seeks for some accommodation.
Lordship, in item number, in writ petition 4535, the verification is going on. Will need require 1 week time. In item 453, we received the instruction, Lordship. In writ petition number 4538, we received the instruction, Lordship. Verification has been done by the chief engineer, and the admitted amount is 18 lakhs, your Lordship.
Claim is how much?
23 lakhs.
Okay,
68,763.
Then in writ petition number 4541, the admitted amount is 2.15 lakhs.
That is what I prayed for, my lord. Yes.
1 lakhs. And in 4560, the verification is still going on, Lordship. In 2, I have received. In 2, I'm awaiting a Lordship.
So
4538 and 4541 can be closed, your Lordship. These 2 can be closed, your Lordship.
You'll pay for it.
We'll pay for it because it's the admitted amount and verified by chief engineer.
Orders.
Have you filed the affidavit?
We have not filed the affidavit.
You placed on record.
Very well, Lord.
51 can be closed because my prayer for 2,15,000 tallies with their assessment. So 51 can be closed. And regarding 50, which I have prayed for is 23 lakhs, and the amount which they have admitted.
Let's see one by one. 435 and 4560,
Yes. That instruction I'm awaiting on that too.
You write in the item 49, Heard Mr. So-and-so, Land Council for the petitioner. Mr. R.R. Gogoi,
Yes,
Standing Council,
PHE department.
PHE department, submits that as referenced for and granted further 2 weeks time to verify the claim of the petitioner. Christoph. Then same order will be item 52. 52, 52. Then 50 is what? 50, there's a difference.
Yes.
There's a difference.
There it is.
Mr. M. Sharma, so and so 50, Heard Mr. M. Sharma, Mr. So and so, Gogoi, Standing Council, PhD. Submits that on verification, although the claim of the petitioner is rupees,
My lord,
is rupees.
The amount is 23 lakhs.
23 lakhs.
58,000.
58,000.
763.
763.
Yes.
Comma, on verification, the admitted amount is rupees
18.0634.
18.0634. Christoph. Therefore, he may be allowed a week's time to brought on record by affidavit. You file it,
Very well, Lordship.
And item 51.
51.
Just give me. Item 50.
This can be closed, your Lordship. His claim is 2.15. We admitted 2.15.
When you are paying?
The span of 3 months, your Lordship. Because
3 months?
Yes, because since they admitted now, we have to go for the funds for the finance department. Ceilings will be granted, funds will be placed.
Item 52, right? 51.
51, my lord.
Mr. Heard Mr. M. Sharma, Land Council for the petitioner, and Mr. R.R. Gogoi, Land Standing Council for PhD, for respondents. Next parent. claim in this writ petition is for release of an outstanding dues to the petitioner amounting to rupees, what is 2 lakhs?
2 lakh.
2 lakhs 15,000.
2 lakhs 15,000 for the what? On account of the work ordered on account of the execution of work for supply, delivery and installation of 2 number of standalone community water purification plant within bracket CWPP bracket with specific features under jail-driven mission issued by the respondent number 4 under Jorhat Division, Jorhat. Next paragraph. The petitioner is a partnership firm incorporated having its registered offices Mayor Garden, ABC, GS Road, Guwahati, Kamrup within bracket M, bracket close, Assam. Next. Pursuant to the tender process initiated by the respondent authorities, the petitioner was awarded with work orders issued for supply, delivery, and installation of so and so, same list of. It is contended by the petitioner that the petitioner has executed the work of supply and delivery, delivery and installation with the satisfaction of the concerned authorities. However, the payment of this is entire amount or what?
No, my lord. Part payments have been made.
The
pending payments.
the respondent authorities have made a part payment. However, an outstanding amount of rupees 2,15,000 has not been released as yet. This court on while issuing notice. No, notice was not issued. Notice was issued.
Notice was issued, my lord. Notice was issued.
No. Next parent. Mr. Gogoi, London, R.R. Gogoi, London Council for the petitioner. And then standing council, PhD. London standing council, not PhD, huh? London standing council. On instruction, submits that the amount of rupees 21 lakhs 50,000.
15,000.
15,000. As claimed the petitioner is found to be admitted amount for which the amount is admitted amount list of. However, for payment, however, for payment for release of the said amount, a considerable time may be required to process this list of. Therefore, praise that petition the further three weeks.
3 months ago.
Further 3 months time may be granted to the petitioner and to the respondent authorities to release the said amount of 2,15,000 to the petitioner. Next parent. Having considered that the amount of rupees 2,15,000 claimed by the petitioner is clearly admitted by the respondent authorities, I deem it appropriate to dispose of this writ petition with a direction to the respondent authorities to make payment of the said admitted amount. Accordingly, writ petition is then disposed of with a direction to the respondent number, all the respondents.
My lord, the respondents, the relevant respondent will be the executive engineer.
He will release the money, lordship.
Respondents
6.
Phone number 6, my lord.
particularly the the executive engineer, public health engineering department, Jorhat division, Jorhat, to release the outstanding, admitted outstanding amount of rupees 2,15,000 to the petitioner within a period of 3 months from today.
Date of the certified copy. On a date or the certified copy order.
No.
Let him submit the order before this authority, your lordship, on date of that.
Within a period of 3 months from the date of receipt of the certified copy of this order, the petitioner stands disposed of.
Grateful, my lord.
In terms of above.
Obliged, lordship.
That's all. Whatever this 56 is also allowed. Same. List along with those, huh? I don't know why this.
I think 52